I'm Tanya Iser. I'm an investigative reporter here at Channel 8, joined today by Erin Hendricks.
Good morning.
Thank you for coming back. She's been with us for some of my prior trials that I've done this with, and she's always a fun guest. And so we're going to... Ryan, do we have a package to play? A story?
Yeah, William Joy's package.
Oh, okay. I should have asked that. Sorry, guys. Anyway, so we're gonna go ahead and play William Joy's story from yesterday that'll recap yesterday's events, and then we'll get started with the conversation.
In policing, we're dealing with human beings.
All day Tuesday, experts for Aaron Dean's defense and the prosecution dissected every action he took October 12, 2019, including killing Atatiana Jefferson.
Put your hands up! Show me your hands!
Dr. Jay Coons, a Sam Houston State law enforcement professor, testified Dean's actions followed policies.
When a firearm is pointed at you, shoot that individual. You are in extreme danger.
Coons got into a testy back and forth with the prosecution, who called their own rebuttal witness.
I was tactically inefficient and in violation of a number of the policies and procedures of the Fort Worth Police Department.
Jonathan Priest, a forensic analyst and former officer in Denver, said Dean and his partner should have either announced their presence or backed off and called for backup instead of going to the back of the home.
They're also violating their policy, their procedures, and it made zero tactical sense.
The defense tried to focus on Jefferson's gun, continually trying to convince the jury that Dean could have seen it and that he was justified killing her. The prosecution argued he shouldn't have been there at all and Jefferson was reacting normally.
Atatiana Jefferson had the opportunity to observe the defendant's orders?
No.
Both sides closed this evening, and tomorrow will likely get closing arguments and put the case in the jury's hands. In Fort Worth, I'm William Joy.
Okay, so Thanks for joining us this morning. I'm going to call Rebecca Lopez, our senior crime and criminal justice reporter. She's at the courthouse, so I want to get her to give us an update on what she's seeing and hearing and just give us a sense of how things are going. Okay, so we're going to call her. We're doing this old school. Hold on a sec. All right, Rebecca, I'm going to put you on speaker so you can tell folks what's going on. Hold on a sec. All right, go ahead.
Well, I mean, there's obviously a different feel and vibe today here at the courthouse where there are extra police. In fact, they have brought in DPS troopers. I saw several of them come in, and they actually brought them up here to the 7th floor. I think they'll have some in the courtroom as well. And, just a lot of tension here at the courthouse this morning as they prepare for the verdict. I've talked to family members that say, they hope, well, not any of the ones that are under a gag order, just family friends that are saying, listen, we really hope that this verdict goes our way. If not, there might be some unrest. So the judge, I know, is going to make sure that the security is pretty tight here at the courthouse before the verdict is read out loud. Obviously, there's still, we still have a little process. We have the closing arguments, and he'll read the charges to the jury. And then, this jury will begin deliberating.
Tell us a little bit about the security you see there this morning.
Well, there were a lot of bike patrol officers outside the courthouse, and again, I saw a bunch of DPS troopers. Initially, they were downstairs, sort of surrounding the area where Aaron Dean typically comes in, and then now they're up here on the 7th floor where the case is happening, where the trial is happening. They're all up here, and I was talking to one of them. I said, "Oh, obviously you guys were brought in for reinforcement." He says, "Yeah, I hope we're not needed today." And then they went back to the back where Dean and the lawyers and the judge and everybody are. So, and I suspect, that with any police department, as we remember from Amber Geiger, they would have their tactical teams, their crime response teams, I'm sure, prepared and ready to go just in case, there is any unrest if this verdict is not guilty. And they just have to prepare for that. And based on what I am hearing from the people that are coming here, that are close to this case on Atatiana's side, they're ready to hit the streets.
Now, are you getting any sense of when the courtroom's going to open and we're going to start to see some action?
Well, I know they're confiscating people's phones and everything right now. They've got a waiting area. They did open the auxiliary room, so I'm suspecting that it's going to happen anytime soon. And then, one of the things that they were doing last night was the judge did give the jury time to go over their notes, because he says, look, you're going to have to go over your notes right now because we're going to hit the ground running. And he also was going over the charges that he's going to read to the jury with the attorneys. Of course, they go through the verbiage and sometimes line by line until they decide what's going to go in there and what is, they have a right to object to certain things and or they want certain things added. So they were kind of haggling over all of that last night.
Well, I know this judge has run a pretty tight ship, so I would expect he will be starting forthwith. And somebody's asking about Lee Merritt. We never have really heard any more about Lee Merritt.
I have not heard anything else, but he is still sworn in as a witness, so it could be that at some point, if there is a guilty verdict, then Merritt might be called in to testify, because, he apparently has talked to Zion several times, the nephew, and he's also been very close to the family and might have, we don't know for sure, but there was conversation in the courtroom that maybe he had shown a video to Zion. So, which the prosecutors say they never showed him. So it looks like he might have seen that video, and they could think of only one place that he might have seen that. So all of that, I'm sure the judge is, considering if there's going to be any kind of contempt of court or any kind of sanctions imposed on him for violating a gag order. And he's violated it multiple times.
And Dean has not arrived yet at court this morning?
I have not seen him. Typically, he comes in with, 2 or 3 people with him, sheriff's deputies. I have not seen him arrive this morning. So,
Okay.
but he's probably already in the courthouse. Typically, he gets here early, a good hour and a half before. So I suspect he's here. We just haven't seen him. They are taking him a different way. They're not having him or the jurors, by the way, walk through the courthouse. They have different passages and ways that they are getting even the jurors. I mean, one of the things that the jury was concerned about during jury selection, the potential jurors kept asking about security. And we know this is a high-profile case. How are you going to protect us? And so the judge came up with a plan just for the jurors and how they were going to deal with them and get them in and out. And remember that if they do not come to a verdict today, after deliberating, the judge is going to sequester them. And when you are sequestered as a juror, you're not allowed to, I mean, you don't have your phone. Typically they don't let you have your phone. They don't let you have a television. They are very strict about what you can even have in your room, and because they want them just focused on coming to a verdict. So he did say that he would sequester this jury during deliberations, throughout the deliberations. And also, again, for security reasons, you can't have a juror going home when there's all this tension on both sides in this courthouse and what their job is ahead of them.
Well, they've got a tough job, no doubt about it. I'm kind of glad I'm not one of them. So
yeah, no,
I know way too much to be one of them anyway. So
Right.
yeah.
So-
So there's definitely a different vibe. Reminds me reminiscent of, how we were all sort of on edge when the Amber Geiger verdict was coming in.
I suspect that this is not going to go the same route in terms of some of the courtroom, I hate to use the word theatrics that we saw in that trial. I don't think we're going to see anything like that in this one. So,
No, this judge is very, straightforward. I don't see that happening.
I don't see hugs and Bibles in this courtroom coming our way.
I don't see him doing that. He's pretty
He's very down the line.
Straight arrow.
Exactly.
Yes,
so,
yeah.
all right. Well, I'm going to let you go, Rebecca. I'm going to chit chat here with Aaron until we get things kicked off. So I appreciate it. Thank
All
you.
right. Okay.
Bye bye.
Bye.
Well, Aaron, what do you think?
I feel you imagining what it's like to be the jurors and not wanting to sit in that seat. They've got a big job, and I don't think it's going to be easy. We haven't been able to see the charging conference where the lawyers are discussing the instructions that will go to the jury, but I know that reading and interpreting and implying a jury instruction is not an easy task.
Because these are lay people.
Regular people. We don't know, are they doctors, are they bankers, are they landscapers, are they stay-at-home moms, maybe English is a second language, maybe they've never seen a courtroom or been involved in anything legal, anything police. And it's not like the jury instruction is written in a way that just any old person can understand. I mean, we've been reading jury instructions for years, decades, and still it takes a minute to go back and unpack the law definitions and the applications of the law to the facts, and then what order you've got to go in, and it's all very rigid. And if you're a dutiful juror, you feel like
you go through it step by step.
You've got to go in order because that's the instructions, and
sounds
like hard work.
It does sound like hard work, and I would not, like I said, I would not want to be in their shoes. What do you think the chances are? Of course, I always bear in mind that I'm always wrong on all my predictions, so I'm just going to say that again, that I'm always wrong. What do you think the chances are that we'll see lesser included in this case?
Well, we talked about this for a minute this morning, you and I predicted that there would be no lesser included instruction given the testimony of the former officer. Mr. Dean said that when he acted intentionally.
But could the judge decide to allow it anyway?
Sure. If the defense or the state, if either party makes a request for a lesser included, I think that typically the judge is going to include the instruction. Of course, if someone fights hard against it and suggests that it wasn't raised by the evidence, he could not include the instruction. If it's not requested, it won't be in there. I don't think the judge is going to...
He's not going to unilaterally.
Right, yeah. Do it on his own. And I think it would have to have been requested. If that happened yesterday or this morning, would have to be requested.
Yeah. Do you foresee if you were a defense attorney, would you ask for a lesser included?
Whew, that's hard. If you want the jury to be straight and decide not guilty and don't give them an option for a lower crime, you don't request it. Just make them decide.
If you're pretty confident in your case.
If you're pretty confident and you feel like the state hasn't proven it or that the state hasn't defeated the self-defense claim, you just want a straight murder or not,
right.
Justified or not, lawful or not, generally. But I guess if you are thinking to yourself, there's a chance based on testimony, based on the battle of the experts, if there's a chance that a fact finder could determine that his behavior was reckless, and I don't mean all of his behavior, I mean his behavior in the moment that he fired his weapon, then yeah, you have to ask for it because so a jury cannot give post-conviction community supervision on a murder. Not that anybody's talking about that, not that probation's in the mix, but to be fair legally, if an individual is eligible for probation and they're found guilty of manslaughter, they could possibly be given post-conviction community supervision. Now I say that and then I think about the deadly weapon finding, so I'm gonna reserve comment, but I think that if the defense thinks there's a a fact finder could think Dean's actions were reckless, then I think maybe they would ask for the manslaughter instruction.
So some folks are asking about, are we going to have closing arguments today? Yes. So both sides rested and closed yesterday, and so we're going to have closing arguments. They're saying around 9. Well, it's 9:03. And while this judge has run a fairly tight ship, it is court, and they do not operate on our time schedule.
And there are 12 jurors and 2 alternates,
yes.
Do we think?
Yes.
So that's 14 individuals who all have different coffee and snack and restroom schedules,
Right.
They all have to be in the same place at the same time. It also depends on the sheriffs who are escorting them in and out of the courtroom, the judge, the court reporter, parties, the litigants,
there's a lot of moving parts here, yeah. And the judge has told us that once they do closing arguments and the jury goes out to deliberate, they're going to close the courtroom. And in Dallas, whenever we've had trials like this that we've done, there's the little red button on the wall,
right?
And every time
light,
and every time the jury has a question, that light comes on, and you know, okay, and then we all kind of run around and figure out, and we try to read the tea leaves about what the question means. But this time, apparently it's a buzzer, but we're not going to hear it. And then they're going to call everybody back in, we'll hear the question, and it'll be, who knows how long all that will last.
And there are other considerations, because if the charge is read, the parties make argument, and then the jury is excused to go be in deliberations. If the jury wishes, they could start with a break. Depending on what the timing is, let's say we're bumping up against 11:30 by the time they break. Maybe the jury says we'd prefer to break first for our lunch and then we'll start deliberating, so that could cause a little delay.
Yeah, you never know on these things. Yeah, what's up, Ryan?
Explain what they're going to see on the stream during deliberations and kind of what to expect from our end. I mean, we're not going to be on for...
Well, no, during deliberations, no, I will not be talking ad nauseum, because that would be very difficult to do. So our plan is that during deliberations, we're going to put up a graphic that'll just say, did we decide jury deliberating or something like that?
Yeah, we'll have something up, and then we can check in with any updates.
Yeah, and then whenever questions are read, we'll come out, we'll talk about it, and we'll periodically be popping up on the stream during deliberations if there if Rebecca has updates or something from the courthouse. if we have something to talk about, we'll definitely talk about it. But it's, deliberations are just that you wait, and so we'll be waiting. So
Check in on the chat too. So.
yeah, and I'll be keeping an eye on the chat as well. I mean, we're not gonna run away. It's just we're gonna be monitoring it and doing that sort of thing. So I want to try to answer folks' questions here. People are asking, why can't the jury take their notes into deliberation?
That's such a good question. Because it seems logical that the jurors are taking notes during testimony and evidence. Why can't the jurors rely on their own notes? And the simple fact is that the judge, the process requires that the juries rely on their memories, which is to say that, like, let's say juror A takes down a bunch of notes about testimony, and juror B takes down a bunch of notes about the same testimony, and there's a conflict. Well, each individual juror has to recall the testimony as he or she consumed it, and they can't be affecting one another's perception. I mean, they can argue about it and deliberate about it, but if they've got their notes and then they all start comparing notes and then they're thinking about the notes as if it's evidence, but it's not.
It's their notes.
Yeah, it's just their thoughts maybe on paper. So that's probably why Judge gave them the chance to review their notes before they had to turn them in. They don't get to keep them.
Somebody's asking who's going to sentence him, the jury or the judge. I'm going to double check that with Rebecca, but I believe he has chosen the jury.
Well, and of course in Texas you can elect, and you have to elect.
I believe he chose the jury.
Yeah.
I mean, let me double check that with Lopez. That is my recollection, but the older I get, the less stable my memory is. So let's talk about, while I'm texting her, let's talk about, the burden in this case rests with the prosecution. And how tough is that burden to meet in a case like this?
No matter what, they've got to prove their case beyond a reasonable doubt. And if self-defense is raised, which it has been, they also have the burden to defeat that defense. So they've got to prove that it was murder beyond all reasonable doubt in order to secure.
And that's a heavy burden.
Right. That's beyond. Some people say if you have a single doubt in your mind that's based on reason, not based on silliness, but based on a reasonable conclusion, that single doubt would be enough to prevent you as a juror from voting guilty. So, after the first days of testimony, the prosecution rests. If everything stopped right there, it would still wholly rest on the prosecution to reach their burden.
Because they have to prove it.
They have to prove it. Now, once that self-defense, that justification was raised, the state still maintains the burden to disprove that or to overcome that it was in fact self-defense. So, same thing. If any single juror has a single doubt based in reason that it wasn't self-defense, then they have to find in favor of the accused and not return a murder verdict, a guilty verdict for murder. Yeah. So I do think, I agree with you. I think it's a heavy burden, and it's all on the state. They do the accusing, they have to do the proving, is what people often say. I'm sure you've heard that 1,000 times.
So, we have a situation here. Dean testified, and folks have asked this before. Dean didn't legally have to testify, but why did he need to testify?
Well, some other great lawyer who you interviewed last week.
Your husband?
Maybe so. Said they've got to hear it. Tolly said, Dean's got to tell his story. He's got to give his recall of the facts for anyone to really believe that he acted in self-defense. He's got to tell us. There's this objective standard about whether his behavior was reasonable, but there's also a subjective component. And how are we going to know whether the shooter, who's accused of murder, was shooting with or without justification from his subjective perspective unless we hear from him? So he never had talked. He had never given a statement. Right. He had nenever interviewed.
Right.
So the jury, in order to know his perspective, had to hear it from the horse's mouth.
So during his testimony, when he was cross-examined, I really do think the prosecutor did a really good job. I mean, of pinning him down and getting him to acknowledge that a number of the things he did was bad police work, and that he made a number of choices that probably weren't the best. But is that enough?
Right.
I mean, does bad police work add up to criminality?
Right. 'Cause we talked about this morning as well. So if
That's why I want to bring our conversations to
poor,
that.
yes, of course, preview. If poor police decision making is tantamount to or the same as unlawful behavior, that's critically important, because if the jury is told that an individual has the right to use deadly force in defense of self unless he's engaging in unlawful activity at the time that he uses the deadly force, that's very important. But there's not a whole bunch of clarity on whether, well, there may be differing opinions about how clear it is, but whether Dean's poor choices or C- or however he was told to grade himself.
He gave himself a B.
Oh, wow.
I mean, I would definitely say it was not a B.
So if Tanya gives him a C-, D+, F, I don't know what it may be. If Dean gives himself a B, either way, if his police decision making was not sound, and if that's the same as engaging in lawful activity, then is he stripped of his right to use deadly force in defense of self? That could be really important, but that's going to be a fact issue.
And that's going to be for the jury to determine.
That's going to be for the jury to determine. They have to decide, well, was his behavior unlawful when he's following or not following police procedure? There was also not a whole lot of clarity from the experts on whether he was per se, like absolutely in violation of police procedure. Was there? Did I miss that? Was there certainty on whether his entering, I think the biggest point is entering the backyard?
Yeah, because the prosecution expert, basically said there were concerns that it was a warrantless search, but generally, engaging in bad police work, it doesn't add up to criminality if it's just you're not,
following procedure.
Right, because I think and the question is the jury going to say, okay, he made mistakes in the lead up, right? He's a rookie officer, he made a number of mistakes in the lead up, but at the moment that he fires the shot, he was
acting in
reasonable fear for his life.
Right.
To me, that's going to be the big question, how they're going to look at all that.
Yeah, I agree with you, and I also feel like when we talk about best practices, like in every industry, there's best practices in banking, and there's best practices in lawyering, and probably best practices in media. So if he's not engaging in best practices as a police officer, but he still, as an individual, acted justifiably when he fired his weapon, then he may be justified, and self-defense may apply, and he may not be found guilty of murder. But if someone decides that failing to follow best practices or failing to follow procedure, or C- police decision making, is the same as criminal activity, criminal trespass. Someone I spoke to, a friend of mine recently, was hearing the story for the first time from Tali and me. He hadn't seen it on the news, he hadn't heard about it. And as Tali told the story, our friend said, wait a minute. So he went into that backyard, he was just prowling around her house, her grandmother's house. And when he used that word prowling, that sounded like a criminal word, right? I mean, if somebody's prowling, are they breaking the law? Now, that's one perspective. And if that's the way the jury consumed the evidence, and that's the way the jury perceived the testimony, they may not afford him that self-defense claim. They may say, sorry, we believe the state proved its case beyond a reasonable doubt, and we don't believe that it was self-defense.
Or they may they may decide that because they believe they had a possible burglary, that even though by policy, well, this is what one of the experts said.
Right.
The prosecution expert said is that if you believe it's a possible burglary, they read the general orders, which says you're supposed to lock down the scene, call for backup, get a canine. And, but they may say, okay, well, even though he didn't do that, he was lawful in going into the backyard because he thought he was checking out a burglary.
Right, and based on his subjective belief, yeah.
And they get to determine that, right?
That is up to the jury. I think that the judge isn't going to intervene and instruct them on how to characterize Aaron Dean's behavior. It's totally up to the jurors. And you're right. Even if the expert said what the expert said, and they said, yeah, you didn't exactly do it right, but if the jury thinks to themselves, each individual, but Dean told us he believed that, and that's what prompted him to act and take those steps, then they're gonna maybe let him be, they're gonna afford him justification, and they will acquit him. They might acquit him.
Well, and I've said it before and I'll say it again, whether he is found guilty or not guilty, I firmly believe there are lessons in police work here that police departments need to learn from this, because, and every time I've seen one of these situations happen, it feels like it's the officer gets in a rush, rather than slowing it down. Because now that doesn't add up necessarily to criminality. I'm not talking about criminality here at this point. I'm talking about maybe you call a supervisor. Maybe you walk across and talk to James Smith, the man that made the call, and just get some more information, folks. Like, slow it down.
Maybe you confer with your partner.
Yeah, maybe you, I don't know, get Atatiana's phone number and, I don't know, call her. What a concept. It's just this rush, and whether they decide that going into the backyard adds up to some sort of criminality, which doesn't afford him the reasonableness claim, okay, fine, whatever. But you placed yourself in a situation, and you could have slowed it down, and this didn't have to happen. That's just where I'm at with it.
It didn't have to happen.
It didn't have to happen.
But was it murder?
That's a whole different subject.
I think probably every human being on earth thinks to themselves right now, it didn't have to happen. It could have gone differently.
And tell me how Fort Worth police officers would react if Atatiana Jefferson shoots and kills Aaron Dean, who has not announced himself, and gone into her backyard at 2:30 in the morning. Tell me what they'd like to see happen. Are they going to afford her the same reasonableness justification?
I should
really?
Hope so.
Because I guarantee you, they'd want her charged with,
killing
death penalty
offenses.
I mean, come on.
However, if you take his uniform off, and he's some man in her backyard.
Yeah. I just, again, this is not about whether the jury for me at this point, what I'm talking about is just that
lessons.
I think every single police chief in North Texas and maybe across this country ought to go back and watch his testimony, because the other problem here is you had two rookie cops. They were in the same academy class together. These two officers had very little time on the street, and they were placed in a very higher crime area. Dart said that pretty much any crime that could happen happened in that area. Well, that could be
the case for any area.
Right.
That could be the case for any area.
But do you approach every single call you go to that every single person you're going to deal with is a potential criminal? I mean,
but isn't that exactly what the police do? They protect.
But you're telling me
serve.
He goes in that backyard in South Lake?
Well, it's interesting. I was talking to a colleague, our darling, brilliant legal assistant, who's a City of Dallas resident. She remembers being at a community meeting or in a forum where she was, where there was chatter that person calls the cops and says, "Hey, there's a prowler in my neighbor's backyard. There's somebody in the neighbor's backyard. Can you please go out and help?" And the City of Dallas officers say, "Well, ma'am, we'd love to help you, but we can't go into your neighbor's backyard without your neighbor's permission." Even though this concerned individual says, "Hey, I think there's criminal behavior in my neighbor's backyard." Maybe they don't articulate it that way, but I think it's very interesting because you said, would Dean have gone into that neighbor into that backyard and other neighborhoods in
same
Tarrant
situation.
County?
Yeah, same scenario. I mean, it's a tough one. And look, I've had people in the chat that think I'm taking one side or the other. Look, I'm not taking anybody's side, because my belief is that, beyond, the jury's going to decide what the jury's going to decide.
Right.
But I just strongly believe we have to learn from these situations, and it requires better police training, and frankly, a little common sense here. I mean, common sense could have gone a whole long way towards avoiding what happened here.
I hear you, but I challenge you that really common sense, I mean, we hope that all officers have that, but the training and then how he implemented his own training, I mean, that's an individual decision. If he received training and then he implements it in a way that is contrary to how he was instructed, that's his fault.
Right.
That's on him. Meanwhile, I still go back to what you said earlier. If he had slowed things down, I'm imagining Aaron Dean and his female partner and how they approached the house and how they went into the backyard, and I don't know what kind of communication officers should have with one another when working in a two-man situation. Two-man meaning, two officer. They're in one squad car.
No, they actually were in two squad
two
cars.
vehicles.
She actually got there just a little bit before him.
Right. Well, so they're together and they
Right.
are colleagues. They are
And
in
they're
that moment
and
partners.
they're also in the same. They're also from the same academy class. So these two people, they know each other. They've spent quite a bit of time together. And when you're in academy class together, there's a lot
There's
of bonding.
probably got to be bonding, yeah. But regardless, any given Fort Worth police officer and any given other Fort Worth police officer, if they're responding to the same call and they're at the same scene, what's that communication look like? I mean, could there have been an opportunity to confer? She's behind him, he's ahead of her, how she holds her weapon, how he holds his. How are they, what's the communication look like? Are they silent?
There was
Can
little.
there be nonverbal communication?
There can be a lot of stuff that doesn't necessarily show up on a body cam. Ryan,
Rebecca says no one's allowed in the courtroom yet. They're still kind of getting security stuff set up. There's a crowd in the hallway, obviously, people waiting to get in.
yeah. So
No rumblings, if you want to pass that along.
So Ryan, who is our running our equipment over there, and who is he's off scene. He's off to the side. Y'all haven't actually met him, which is really kind of unfortunate because he's really a nice guy.
Oh, it's okay.
You don't want our YouTube jury to meet? No, I guess not. Okay. Anyway, he's saying. The guy in the comments. He's the one that whenever you see the WFA comments, he's that guy posting those things. So you have complaints, direct them at him. Anyway, so Ryan is saying that he's hearing from Rebecca that they haven't opened the courtroom yet. There's a crowd gathering in the hallway waiting to get in. The judge had said they would start closing arguments at 9, but we're in this, waiting mode. What are they doing? Why are we waiting?
They're assembling. Somebody's late. Somebody's caught in traffic.
I got caught in traffic this morning, so
That's right.
yeah, because 30 was
Bad.
a parking lot. There was a
Yeah.
overturned 18-wheeler, and they closed down every single lane at Ballpark, and I ended up having to make a huge detour.
Work
to get in.
around.
Yeah.
Yeah, so it could be traffic. Somebody's late. Who knows? Somebody could be ill. Somebody could be thirsty. Someone needs a quick restroom break before they're brought into the courtroom, because if they're going to sit in the courtroom and hear the reading of the instruction, which is pages of words, that's going to take 30 minutes just to hear the judge read the instructions. And then the judge may give additional admonishments to the participants, the litigants, the observers, the jury themselves. And then the arguments, he's giving 45 minutes aside.
I believe so. I haven't actually heard them say, but that's typical, right?
Maybe. Sometimes it could be 30 minutes. Sometimes it could be an hour. It just depends.
On the judge.
On the judge, and also on the requests of the parties. But then there's a break between the speakers. Of course, the closing arguments, the prosecution gets to start and the prosecution gets to end, right? So they could break up that argument and just kind of the machinations in the court, the moving around, that takes extra minutes here and there. So these are jurors who are fixing to head into the courtroom to maybe work for 3 solid hours with no break. Mm-hmm. So, people are tending to their business. Who knows what else is going on if, we don't know.
I can see in the comments that Jerry Jones doesn't like me very much, but thank you for watching our stream. No, I know it's not that Jerry Jones. I'm just saying somebody who's calling themselves Jerry Jones. And anyway, I appreciate you staying on our stream. And it's interesting because he thinks I'm a cop hater, which is really kind of funny because I'm absolutely not a cop hater. Actually, a lot of my really good friends are police officers or retired police officers. I just have a belief in good police work. And if you're doing good police work, hey, you're going to have my support. But if I think you've done bad police work, I'm going to call it out.
Some people are going to say that Aaron Dean did good police work. Some people are going to say that he did not.
Well, I also think you could say it was bad police work and also say that maybe it wasn't criminal. Like I think
Right.
I think you can hold both of those thoughts. Now I'm going to reserve judgment about whether or not it's criminal or not because that's up to the jury to decide. But I think it's pretty clear that there were mistakes made in this case, but whether or not they rise to the level of criminality is a separate situation. So I'm going to kind of go through. I'm looking at some of these questions here that folks are asking. Somebody's asking about why, there were some, Aaron Dean had some evaluations, and I believe it was field training that said he had tunnel vision, that he would get tunnel vision. And somebody's asking, why that didn't get used. If you were, read the tea leaves and why didn't that come in? Or what would be your thought on why that didn't come in?
I suppose, could that maybe cut both ways? You say there were evaluations that the officer had tunnel vision. Obviously, there's a negative connotation. Tunnel vision meaning to the exclusion of all other facts, I'm only focused on. At the same time, what if that's actually not negative? What if a police expert comes in and says, we want our officer to train in on the threat assessment, or we want an officer to respond to a scene and focus only on the scene and not consider whatever other, I can't know for sure why they did or didn't use that tidbit of testimony, but I don't know.
And also maybe they didn't open the door.
Sure, and it may not.
And it
may
could
not
cut
have
both
been
ways.
relevant, and it may not have been relevant. Which I know that may seem silly because you're thinking, the viewers are thinking, well, of course it's relevant, but maybe it's not admissible if it's not deemed admissible by the judge. Maybe was it even offered? Was it limited out by a pretrial motion? I mean, there could be a number of reasons it wasn't used.
So we haven't talked about Zion's testimony. So Zion, when he was originally questioned after, within hours of this event, and then in subsequent conversations with with the state, always said that Atatiana got her gun out of her purse and that she pointed it at that window. Now, when he testified, he was the first witness on the stand that Monday. He testified that she had the gun, she got out of her purse, but that she kept it at her side, and he demonstrated that in court. What import do you think the jury will take to that? I mean, because
so either the child's testimony did not corroborate Aaron Dean's testimony, or the information that he had previously given did corroborate Aaron Dean's testimony. So and the fact that it was different in court than when the child was previously questioned, some people may really read a lot into that and really be concerned about the impropriety of the conversations. At the same time, with the child before he testified, at the same time, you don't put a witness, even a child witness, on the witness stand without some level of preparation. And I don't mean preparation like tell the kid what to say or how to feel, but preparation for the experience, like what it looks like.
Well, they did put it. They did.
Sure.
They said they took him down to the court and they showed him the courtroom. I mean, I don't know.
So I mean, I guess there's this theory that maybe he was told, or his testimony was influenced.
That's certainly what the prosecution. I mean, not the prosecution. That's certainly what the defense inferred. Well, more than inferred, they pretty much indicated that they believed that his testimony, that somebody had influenced his testimony, and they kind of inferred it was Mr. Merritt, which was why we were kind of all hoping we'd see him testify. But I think probably for the purposes of this, it just ended up not being relevant. But
and he's not a fact witness,
right?
Yeah.
And I think that, it's just going to depend on, whether the jury decides to place more stock on his original testimony, on his original statement because certainly his original statement would tend to back up Aaron Dean's version of events of how it went down.
Because if the officer's confronted with facing a person who's armed but not aiming their gun at him, that's a whole lot different than if an officer or any individual is facing someone who's armed and pointing the weapon at your person. And if the child's testimony doesn't corroborate Aaron Dean, then all the jury has is that Aaron Dean said so. And that could be enough. They could believe him without regard to Zion's perspective. It's completely up to the jury and really each individual to believe whichever testimony they want, or to give whichever witness whatever level of credibility they think that witness deserves. I mean, there is something inherently credible about a kiddo sometimes,
Right.
unless there is a concern that he's got a motive to testify falsely, or a bias, or he's been interfered with, or he's been told or made to feel. And then there's also all the stuff about memory and what his memory was then versus his memory was now, and what all has happened between then and now. And
I mean, it's been 3 years, and he's also he was an 8-year-old child at the time of this. You know.
And now he's an 11-year-old child.
Yeah.
What is he,
I
a
mean,
fifth
still
grader,
young.
sixth grader?
Yeah. I mean, my kid is almost 11. He's 6th grade, so he's a little bit older than my son. And so, I've often over the last week and a half tried to put myself in the shoes. Think about my child.
Mm-hmm.
Yeah, my child having to testify in a situation like that, and I frankly can't even imagine it.
Yeah,
like,
no.
I mean, you have small kids too, and
Well, yeah, no, I mean, I have a 6th grader, and I imagine that child being in a room where something happens like what happened to his aunt.
Oh, awful. Like awful on so many different levels. I mean,
and we also don't know what the child's experience has ever been with law enforcement. We don't know at the time, and then since then, we don't know what his family's experience has been with law enforcement. There are definitely many groups of thought on whether the police are good, whether the police are bad. Not many people stop and think, well, maybe police are individuals and they could be flawed and they may have bad features but have some other good features. And there's really kind of, some people have good experiences with law enforcement and some people don't. I have no idea what that child had experienced before that day.
Right.
But without regard to whether the man on the outside of the window who shot his aunt was a woman, a man, an officer, an alien, it was probably terrifying for him. And then fast forward 3 years later, how many days has there been chatter about this in front of him? How many conversations have been had? He's got friends and cousins and schoolmates and classmates and neighbors. I mean, who's talked to him? Who's said things? How has that affected his memory or his recall or his attitude?
Oh yeah,
He's a kid. He's an individual. He's got a right to have his own thoughts and feelings and opinions.
Oh, absolutely. And I'm sure they've gotten him counseling, because I can't even imagine.
I hope so.
Oh, I hope so too. But I think that at least in my experiences in having covered law enforcement for 25 years, I've found most police officers are really good at their jobs and love what they do. In fact, a lot of the stories I've covered over the years where I've covered quote unquote bad cops, actually it was the good cops that came to me and said, hey, you need to know about this, and we don't want to work with this person. So I've never had this perspective that that all law enforcement's bad, because I absolutely don't believe that. And I hate when people think that about my profession, because I think most reporters, most journalists try to do a good job. We try to be honest and we try to be factual. But in any profession, you're always going to have the bad apples. And I'm not even saying Dean is necessarily a bad apple. I think this is, I guess it's really in this case just going to end up being about what the jury determines that they need to consider in this case. Yeah.
I mean, the truth is, Rebecca said something about that the friends of the family who are not subject to the order hope that the verdict goes their way, or there might be some unrest. And I think to myself, whether Dean is found criminally culpable, like murder, whether he's found criminally culpable for that woman's death or not, takes nothing away from the fact that he is actually, factually responsible for her death.
Right.
I mean, he caused her to no longer be alive.
Right.
So, no matter whether he is criminally culpable or not, he.
Are they back in the court?
Yeah, we're going, ready.
All right, let's go.
Defense is ready, Your Honor.
All right.
Everyone may be seated. Tell Mr. Nicholson I need him. Good morning. I apologize for the delay. We've been working. I am going to hand each of you a copy of the jury instructions that you can follow along with me as I'm reading them to you. You will keep those with you, and you may use those to take back to the jury room with you when you begin working, but there will be an original of the court's charge that you will have to use for the official work that you do. So if you are working on something and it is stamped copy, that's not the original. All right? Members of the jury. In any jury trial, there are in effect two judges. I am one of the judges, the other is the jury. It is my duty to preside over the trial and to decide what evidence is proper for your consideration. It is also my duty at the end of the trial to explain to you the rules of law that you must follow and apply in arriving at your verdict. First, I will give you some general instructions that apply in every case. Then I will give you some specific rules of law about this particular case. And finally, I will explain to you the procedures you should follow in your deliberation. General instructions. You as jurors are judges of the facts, but in determining what actually happened, that is, in reaching your decision as to the facts, it is your sworn duty to follow all of the rules of law as I explain them to you. You have no right to disregard or give special attention to any one instruction, or to question the wisdom or correctness of any rule I may state to you. You must not substitute or follow your own notion or opinion as to what the law is or ought to be. It is your duty to apply the law as I explain it to you, regardless of the consequences. It is also your duty to base your verdict solely upon the evidence that has been presented to you in court. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. As you determine the facts, you must consider only the evidence presented during the trial, including the sworn testimony of the witnesses and the exhibits. Remember that any statements, objections, or arguments made by the lawyers are not evidence. The function of the lawyers is to point out those things that are most significant or most helpful to their side of the case, and in so doing to call your attention to certain facts or inferences that might otherwise escape your notice. In the final analysis, however, it is your own recollection and interpretation of the evidence that controls in the case. What the lawyers say is not binding upon you. Also, do not assume from anything I may have done or said during the trial that I have any opinion concerning any of the issues in this case. Except for the instructions to you on the law, you should disregard anything I may have said during the trial in arriving at your own findings as to the facts. In answering the issues submitted to you, you must not be swayed by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feelings. While you should consider only the evidence, You are permitted to draw such reasonable inferences from the testimony and exhibits as you feel are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts which have been established by the evidence. You are to decide whether the state has proved beyond a reasonable doubt that the defendant is guilty of the crime charged. The defendant is not on trial for any act or conduct not alleged in the indictment. Alleged offense. Now, bearing in mind these general instructions, the defendant, Aaron York Dean, stands charged by indictment with the offense of murder, alleged to have been committed on or about the 12th day of October 2019 in Tarrant County, Texas. To this charge, the defendant has pleaded not guilty. Applicable law and definitions. A person commits the offense of murder if he intentionally or knowingly causes the death of an individual, or if he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. Individual means a human being is who is alive. Deadly weapon means a firearm. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. You are instructed that you may consider all relevant facts and circumstances surrounding the killing, if any, and the previous relationship existing between the accused and the deceased, if any, together with all relevant facts and circumstances going to show the condition of the mind of the accused at the time of the offense, if any. Application of law to the facts. Now, if you find from the evidence that the state has proved beyond a reasonable doubt that the defendant, Aaron York Dean, on or about the 12th day of October 2019 in the county of Tarrant, state of Texas, did then and there intentionally or knowingly cause the death of an individual, Atatiana Jefferson, by shooting Atatiana Jefferson with a deadly weapon, to wit, a firearm. Or if you find from the evidence that the state has proved beyond a reasonable doubt that the defendant, Aaron York Dean, on or about the 12th day of October 2019 in the county of Tarrant, state of Texas, did then and there intentionally, with the intent to cause serious bodily injury to Atatiana Jefferson, commit an act clearly dangerous to human life, namely, shooting Atatiana Jefferson with a deadly weapon, to wit, a firearm, and thereby cause the death of Atatiana Jefferson, then you will proceed to Section 4 of these instructions to consider whether the defendant's conduct was justified. If you do not so find, or if you have a reasonable doubt thereof, you will proceed to Section 3 to determine whether the defendant is guilty of the lesser included offense of manslaughter. Lesser included offense, applicable law and definitions. A person commits the offense of manslaughter if he recklessly causes the death of an individual. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Application of law to facts. If you find from the evidence beyond a reasonable doubt that on or about the 12th day of October 2019 in Tarrant County, Texas, the defendant, Aaron York Dean, did then and there recklessly cause the death of an individual, Atatiana Jefferson, by shooting Atatiana Jefferson with a deadly weapon, to wit, a firearm, Then you will proceed to Section 4 to determine whether the defendant's conduct was justified. If you believe from the evidence beyond a reasonable doubt that the defendant is guilty of either murder or manslaughter, but you have a reasonable doubt as to which offense he is guilty, you must resolve that doubt in favor of the defendant and find him guilty of the lesser offense of manslaughter. If you do not so find, or if you have a reasonable doubt thereof, you'll acquit the defendant and say by your verdict not guilty. Defenses. Applicable law and definitions. It is a defense to prosecution that the conduct in question is justified under our law. You are to consider two statutory defenses in determining if the defendant's conduct was justified: self-defense and defense of a third person. The defendant is not required to prove self-defense or defense of a third person. Rather, the state must prove beyond a reasonable doubt that self-defense and defense of a third person do not apply to the defendant's conduct. A reasonable doubt on either of these two defenses requires that the defendant be acquitted. Upon the law of self-defense, you are instructed that a person is justified in using force against another when and to the degree that the actor reasonably believes the force is immediately necessary to protect the actor against the other person's use or attempted use of unlawful force. A person is justified in using deadly force against another if the actor would be justified in using force against the other, as set out above, and when and to the degree the actor reasonably believes the deadly force is immediately necessary to protect the actor against the other person's use or attempted use of unlawful deadly force. A person is justified in using deadly force against another to protect a third person if, under the circumstances as the actor reasonably believes them to be, the actor would be justified in using deadly force, as set out above, to protect the actor against the unlawful deadly force the actor reasonably believes to be threatening the third person he seeks to protect, and the actor reasonably believes that his intervention is immediately necessary to protect the third person. Actor means a person whose criminal responsibility is an issue in a criminal action. Another means a person other than the actor. Person means an individual. Reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the actor. Deadly force means force that is intended or known by the actor to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. Unlawful means criminal or tortious or both, and includes what would be criminal or tortious, but for a defense not amounting to justification or privilege. Application of law to the facts. Now, if you find from the evidence, beyond a reasonable doubt, that the defendant, Aaron York Dean, on or about the 12th day of October 2019 in the County of Tarrant, State of Texas, did then and there intentionally or knowingly cause the death of an individual, Atatiana Jefferson, by shooting Atatiana Jefferson with a deadly weapon, to wit, a firearm, or that the defendant, Aaron York Dean, on or about the 12th day of October 2019 in the County of Tarrant, State of Texas, did then and there intentionally, with the intent to cause serious bodily injury to Atatiana Jefferson, commit an act clearly dangerous to human life, namely shooting Atatiana Jefferson with a deadly weapon, to wit, a firearm, and thereby cause the death of Atatiana Jefferson. Or if you find from the evidence beyond a reasonable doubt that the defendant, Aaron York Dean, on or about the 12th day of October 2019 in the County of Tarrant, State of Texas, did then and there recklessly cause the death of an individual, Atatiana Jefferson, by shooting Atatiana Jefferson with a deadly weapon, to wit, a firearm. But you further find from the evidence, or you have a reasonable doubt thereof, that at the time of the offense, the defendant, Aaron York Dean, used deadly force, and the defendant reasonably believed that his use of deadly force was immediately necessary to protect himself from Atatiana Jefferson's use or attempted use of unlawful deadly force, then you must acquit the defendant of murder and manslaughter and say by your verdict not guilty. Or, if you find from the evidence beyond a reasonable doubt that the defendant, Aaron York Dean, on or about the 12th day of October 2019, County of Tarrant, State of Texas, did then and there intentionally or knowingly cause the death of an individual, Atatiana Jefferson, by shooting Atatiana Jefferson with a deadly weapon, to wit a firearm, or that the defendant, Aaron York Dean, on or about the 12th day of October 2019, in the County of Tarrant, State of Texas, did then and there intentionally, with the intent to cause serious bodily injury to Atatiana Jefferson, commit an act clearly dangerous to human life, namely shooting Atatiana Jefferson with a deadly weapon, to wit a firearm, and thereby cause the death of Atatiana Jefferson. Or if you find from the evidence beyond a reasonable doubt that the defendant, Aaron York Dean, on or about the 12th day of October 2019, in the County of Tarrant, State of Texas, did then and there recklessly cause the death of an individual, Atatiana Jefferson, by shooting Atatiana Jefferson with a deadly weapon, to wit a firearm. But you further find from the evidence, or you have a reasonable doubt thereof, that at the time of the offense and under the circumstances as the defendant, Aaron York Dean, reasonably believed them to be, the defendant would have been justified in using deadly force against Atatiana Jefferson's use or attempted use of unlawful deadly force that he reasonably believed to be threatening the person he sought to protect, Carol Darch, and the defendant reasonably believed that his use of deadly force was immediately necessary to protect another person, Carol Darch, from Atatiana Jefferson's use or attempted use of unlawful deadly force, then you must acquit the defendant of murder and manslaughter and say by your verdict not guilty. Only if you find that the state proved beyond a reasonable doubt that the defendant's conduct was not justified as self-defense or defense of a third person, as explained above, may you find the defendant guilty of either murder or manslaughter. Therefore, if you find beyond a reasonable doubt that the defendant committed murder and you reject beyond a reasonable doubt the justifications of self-defense and defense of a third person, then you must find the defendant guilty of the offense of murder as charged in the indictment. Or if you find beyond a reasonable doubt that the defendant committed the lesser included offense of manslaughter, and you reject beyond a reasonable doubt the justifications of self-defense and defense of third person, then you must find the defendant guilty of manslaughter. Deliberations procedures. It is your duty to consult with one another and to deliberate in an effort to reach agreement if you can do so. Each of you must decide the case for yourself, but only after an impartial consideration of the evidence with your fellow jurors. During your deliberations, do not hesitate to re-examine your own opinions and change your mind if convinced that you were wrong. But do not give up your honest beliefs as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Remember, at all times, you are judges of the facts. Your sole duty is to decide whether the state has proved the defendant guilty beyond a reasonable doubt. When you go to the jury room, the first thing that you should do is select one of your number as your presiding juror who will help to guide your deliberations and will speak for you here in the courtroom. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone, or computer. The internet, any internet service or any text or instant messaging service, or any internet chat room, blog, or website, such as Facebook, Snapchat, Instagram, YouTube, or Twitter, to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict, if any. Any verdict you render must be unanimous. If you need to communicate with me during your deliberations, the presiding juror should write the message, ring the jury call button on the wall, and give it to the bailiff. I will either reply in writing or bring you back into the court to answer your message. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and the weight to be given to their testimony but you're bound to receive the law from the court which is herein given and be governed thereby. And I have signed these instructions as judge. The last page of the instructions contains 3 verdict forms. First verdict form says, we the jury find the defendant Aaron Dean York not guilty. Or, we the jury find the defendant Aaron Dean York guilty of the offense of murder. Or, we the jury find the defendant Aaron Dean York guilty of the offense of manslaughter. If any of those are the unanimous verdict of the jury, the presiding juror should sign his or her name beneath the space in their respective verdict form. Ms. Diener. Oh, Mr. Gill. I'm sorry? I'll change it. I'll get it changed. Ms. Diener.
If you can't feel safe in your own home, where can we feel safe? When you think about your house, you think about safety. It's where you go to retreat, to get away from the world. It's where we grow up. It's where we have kids. It's where we mark on the inside of a doorway when they've gotten taller and taller. It's where we make memories. That's why it's so sacred. That's why it's so important. How many of us during the Thanksgiving holiday were in our own kitchens celebrating with our family? Christmas. Right now, how many of us right now have a Christmas tree in our living room? Why do we do that? Why do we put Christmas lights outside our house? Why do we decorate our homes? Because they're ours, right? Because they're so important. And today, that's exactly why this day is so important. Because the sanctity, the safety of our homes has been compromised by what he did. He took her away. 28 years old, the rest of her life, at the hands of this defendant. The Fort Worth Police Department has good officers. In fact, I've worked with some of the best officers in the state in my career. I trust them with my family. They actually do serve and protect. They don't have preconceived notions about the East Side. They don't go to certain parts of town and say some deserve to be served and protected, but not others. Only the good parts. Only the parts of town that I want to go to. That's not how it works here. Because our community is all of us. And it was her too. And despite what he thought, when he went over to that house, it wasn't a dope deal gone bad, or robbery, or a shooting, high crime area. This is a 28-year-old woman that was a daughter, a sister, an aunt, studying to be a doctor, taking care of her nephew. Yolanda, her mom, was a good person. Zion was a good person. James Smith still lives on the east side. He's a good person. His family are good people. When you put on that badge and you put on that uniform, you say you're going to serve and protect us all. That means her too. And the Fort Worth Police Department, those officers that do serve and protect us and don't have those preconceived notions, that did a thorough investigation in this case, are ashamed that they ever called somebody like him a brother in blue. Because it means something when you put on a badge. It means you don't go to a house with a preconceived notion because you want to have that kind of power. Haven't we all met an officer that just likes being an officer a little too much? I've been pulled over by those guys before. Power hungry, tunnel vision. It's a little scary to me. Those people that we don't...
object to that being outside the record and an expression of the prosecutor's personal opinion, which is absolutely irrelevant to this jury.
Sustained, stay within the record.
Ask the judge, ask you to instruct the jury to disregard the last comments of counsel.
The jury will disregard the last argument.
And throughout the course of their entire investigation, what did the Fort Worth Police Department determine? They talked to all of these witnesses. They looked at all of the evidence in this case. What you guys got over the last 2 weeks, that's what they had. Forensic interview from Zion, witness interviews, they talked to folks, the autopsy report, the photographs, the body camera video, frame by frame by frame, just like what we watched. They went through all of that and they determined it's murder. They issued an arrest warrant and a district judge signed saying this is murder. The question in this case has never been, is it murder? The question that they raised this week was, is it self-defense? Is it self-defense? And what's really important about the court's charge is this is the law that applies. We do not view it based on what he says and only what he says. A person doesn't get to harm another, get up on the stand and say, well, I was doing it in fear of my life. And we just let them go. We just take their word for it. Imagine that scenario. Imagine what would happen if that were the law. Then not one single person would ever be held responsible and accountable for what they do if they can just say it is, so it is. That's not the way that it works. What the law is, and what you guys have in front of you, is that it has to be a reasonable belief and immediately necessary. And so how do we define what's reasonable, right? That's also in your court charge. It's a belief that would be held by an ordinary and prudent person. All of you guys, with what he did out there, was that reasonable? Was that immediately necessary? And here's one very important part, and I can tell you right now, when they get up and talk, they don't want you to focus on this. This is the law. This is what we're charged. This is what we're bound by. Unlawful deadly force. Unlawful force. The only way that this conduct is justified by this defendant is if it's reasonable to all of you, what he did, immediately necessary, and the most important part is her, meaning Atatiana's, unlawful force towards him, or unlawful deadly force. The only way he is justified in his conduct is that it's to the degree the actor reasonably believes the deadly force is immediately necessary to protect the actor being the defendant, against the other person, Atatiana's use of unlawful deadly force. So think about that for a minute. What has been unlawful about what Atatiana did? We have not seen one shred of evidence that anything that Atatiana did was unlawful. In fact, we heard quite the opposite. You can be in your own home, owning a weapon, owning a gun, and you can protect yourself in your home. That's one of the most fundamental rights. That's the reason we all feel so safe. Atatiana Jefferson didn't commit any criminal act by walking up to the window with her gun, thinking someone was outside. It's what many of us would do if we were in our house in the middle of the night in the back bedroom and we hear somebody outside. That's what you would expect us to do, to try to protect ourselves, and in this case, Zion as well. So there's not been any evidence to support anything that she did was unlawful. And you gotta have that. That's what the law says. And if you think about it, it makes sense in this case because she was in her own home. If we can't feel safe there, where in the world are we gonna feel safe? This defendant, when he put on this uniform, he has a tremendous amount of power, right? A tremendous amount of power. And when we talk about what's reasonable, when I talked earlier about the Fort Worth Police Department, when they went through and they did their thorough investigation of what happened out there, they considered all of what you guys have seen as well as the general orders. I put that in here too. You guys can ask for that. If you guys want to go through, you can ask for the general orders. You can see exactly what they say. It's not about what I say they say, or they say, or any kind of spin that the defendant wants to put on it when he took the stand. It's exactly what is written down. It's the very thing that the defense said in opening statement. They followed all the steps and procedures as you are supposed to. An open structure is a silent alarm, and he did everything right. That is what this Jay Coons got up here and said. He wouldn't agree with anything that we asked him, but that's the one thing he said. Everything he did was right. Well, that is not the case. Very first thing, officer receiving the call, that's him, right? He's the sheet officer. He's the main officer. He calls the shots. Step 2, B, all main exit ways should be guarded so as to prevent the escape of any defender. We start there and we fail, right? And that was one amongst the many, 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 many things that he did wrong, because it wasn't important to him to serve and protect that day. It was important for him to get there, get in the action. Power. It can corrupt certain people. Certain people don't need to wear a badge. Certain people do not need to have the power and the control if they do not respect the accountability, and in this case, the grave effect that it had. Now, you guys have the ability today, over 3.5 years, we've waited. They've waited. They've waited for this day. Everybody in this room and all the rooms outside of this room and everybody in this community has waited for today. Because today you say you can't create the danger and then claim self-defense. We want to feel safe in our own home. Today, you guys' decision in this case, finding him guilty, says, I'm holding you responsible. I'm holding you accountable. I'm following the law. And with the power you all have today, which is more power today to change lives, to hold people accountable than most people have in a lifetime. The power you guys have today is to hold him responsible. It's to tell them that it all wasn't in vain. It's to say that she matters. They matter. Eastside matters. We protect everyone. And the law agrees. Everything in this case, all of the evidence in this case, is demanding a guilty verdict. That is exactly what we are asking for from all of you today. We know what he does with power. What are you guys going to do with it? You find him guilty.
Yes. Mr. Gill. Thank you, Your Honor. Morning, ladies and gentlemen. I want to first thank you for the time you've spent here the last week and a half, and all the attention you paid to this case. I mean, it's obvious to me, sitting over here on the other side of the courtroom, that you all take this case very seriously. You paid very close attention. You took a lot of notes. You're very involved in this case, and we appreciate it. Well, thank you for your service. On my behalf, co-counsel Miles, on behalf of Aaron, on behalf of his family, well, thank you. Thank you for being here. Thank you for your service. And I can tell you that it is a very humbling experience to stand up in front of you when you're about to judge my client and have a few minutes to address you and point out to you what I think is important about this case. And the first thing that's important about the case is this jury charge. In it, the judge sets out the law that you'll follow during your deliberation. And one thing that the court's charge doesn't point out, that it's very obvious from everything we've heard in this courtroom this week, is this whole thing is a tragedy. And I'm not going to stand up in front of you and tell you it's not, because it is. It's a tragedy. It was a tragedy on October 12th. It was a tragedy on October 13th. And it's been a tragedy every day since then, and it will continue to be one. But a tragedy doesn't always equal a crime. It doesn't always equal a law violation. Because as the judge points out to you in this charge, and as the state pointed out to you during their opening argument, Atatiana Jefferson had the right to the sanctity of her home. She had the right to protect Zion. The prosecutor called it a fundamental right, even a sacred right. You know what that right is? That's the right of self-defense. And it's the right of defense of a third person, as the judge explains it to you in this charge. And those are fundamental and sacred rights that we have as citizens of the state of Texas. And the judge explains to you that Aaron Dean, as a citizen of the state of Texas, has a right to self-defense. He has a right to defend himself. He has the right to defend a third person, Carol Darch. He has those rights. And the rights we have as citizens, the right to protect ourselves, the right to protect in our home, Atatiana Jefferson's rights the night of October 12th of 2019, she had those rights up until the point that she pointed a firearm at a Fort Worth police officer. Because we never, under the law, ever have the right to point a firearm at a uniformed police officer. The rights stop there. Because that conduct is a first-degree felony under the laws of the state of Texas. And it's a crime, and it's an unlawful act. The judge also tells you in this jury charge that even though Aaron has been arrested for this and charged and indicted, that is not any evidence of his guilt. That the standards for arresting someone and charging someone are very low. The standard of proof of beyond a reasonable doubt is the highest standard we have under our law. It doesn't take much to arrest or charge someone, but it takes a lot of evidence to convict someone, and that's the way our law ought to be. That's been our law from day one when this country was founded. When we passed a Constitution and a Bill of Rights, that's been our law. And it's been the law ever since, and it's the law today. So not only does the state have to convict a person of a crime beyond a reasonable doubt, you heard from this jury charge that the state has to remove all doubt in your mind as to whether or not this was self-defense or defense of a third person. When the judge includes that in a jury charge, it's the state's burden beyond a reasonable doubt to disprove it. The state, in this case, has to prove beyond any and all reasonable doubt that Aaron Dean was not lawfully defending himself or lawfully defending Carol Darch. Judge also tells you in this jury charge that in answering the issues submitted to you, you must not be swayed by mere sentiment, conjecture, sympathy, passion, prejudice, prejudgment, public opinion, or public feelings. It's not your job as members of this community to see that one thing or another happens in this case. It's your decision as jurors based upon the law that the judge gives to you and the evidence that you've heard from that witness stand. There's no one else in this community other than you has heard what you have heard from this witness stand. You are the people that the community has placed in this position of trust. And you are the people that have taken an oath to follow the law of the state of Texas, which is given to you by Judge Gallagher in this jury charge. You are the ones that during the jury selection process of this case said that you could follow the law as Judge Gallagher gives it to you, as it's contained here. During jury selection, you have a right to tell us how you feel about things. That's what you told us. Now, by your oath, you are bound to follow the law. Going back to the charge just briefly, the law of self-defense is set out starting on page 7. And the judge clearly instructs you that it's a justification or a defense under the law to be defending yourself or defending a third person. Halfway down the page, a reasonable doubt on either of these two defenses requires that the defendant be acquitted, found not guilty. A person's justified in using deadly force against another if the actor reasonably believes it's immediately necessary to protect himself or to protect that third party. What is more immediately necessary than having a handgun stuck in your face? And you heard from several people, starting with Aaron, that handgun looked this big when he saw it. And then it was explained to you by Dr. Coons and even by the state's expert, Mr. Priest, that that's called tunnel vision, that the officer's view comes down to 2 or 3 degrees and they focus on that weapon as a robbery victim would. And you've all heard it described in the news, the robbery victim described the weapon as being as big as,
I'm going to object, Your Honor. That's outside the scope of evidence.
Stay within the record.
That's what the expert witnesses
Oh, that's
said.
right. Go ahead.
They described how robbery victims view a firearm with one stuck in their face and they're startled by it. It's huge. It's their focus. It's the focus of the officer's attention when that happens to them. And the experts say that's why when that happens to the officers, they cry out, "Show me your hands, show me your hands." Because that's their focus. The focus is the hands. The focus is the weapon. That's the threat. That's the threat they have to stop. And that's what they do. The application of the law to the facts, page 9. The judge first instructs you on the application of the law of self-defense to the facts of the case and tells you if you have a reasonable doubt or if you believe it was self-defense, you find Aaron not guilty. And then there's an or, and then the judge instructs you on the law of defense of a third person. And if you believe that Aaron was legitimately defending a third person, reasonably defending a third person, or if you have a reasonable doubt about whether he was doing such, then you are to acquit Aaron. And you don't have to agree if it was self-defense or defense of a third person. You just have to agree, you just have to decide in your mind that he reasonably believed he was doing one of those two things. And they happened at the same time. It was the same threat that was threatening both of the officers. It was the same threat that Aaron perceived that he had to act against. The judge tells you that there is a lesser included offense, the offense of manslaughter. Manslaughter is recklessly causing an individual's death. The law of self-defense and the law of defense of a third person applies equally to manslaughter as it does to murder. If you believe that the actions of Aaron constitute manslaughter, then he has a right to defend himself and defend Carol Darge also under those circumstances. And I'm not going to stand up here and insult your intelligence and waste your time by telling you that Aaron did not fire the fatal shot in this case. He did that. He took this witness stand and took an oath, even though he didn't have to, even though the judge would have instructed you to not consider his not testifying for any reason, even though he knew he had to come up here and face cross-examination by experienced prosecutors. He took the witness stand because he wanted you to hear everything. And he told you what happened. And then he was cross-examined. And he told you again what happened. And we know that what Aaron said is correct and truthful because it was the same thing that was said by the other two eyewitnesses to what happened out there that day. We can't really discuss what Aaron told you about what happened without discussing what Zion Carr told you what happened. And remember the circumstances of how Zion Carr testified? He was the state's first witness. And he took this witness stand right over here and took the same oath that everybody else agrees to take. And he answered questions from the state of Texas. And then he answered questions on cross-examination, like any other witness would have to do. And Zion Carr's testimony took a real different turn from the truth during his testimony. Now Zion's a good kid. You can tell from looking at him. He's a good kid. He came in here, he was well-spoken, he was intelligent. But you could tell he was under a lot of pressure. And a lot of time had passed. So Zion succumbed to the pressure and testified differently from the truth. But fortunately, we know what the truth is. Because as soon as police got on the scene, they separated Zion from the scene. And they got him almost immediately to an experienced, trained, qualified forensic interviewer named Lindsay Dula, and Lindsay sat down with him and had a conversation about what he had just seen. And what he saw mirrors what Aaron saw. Because Zion Carr told you he was seated, he was laying on his aunt's bed, further away from the window than she was. And she said, I heard a noise. And she got up and went down by the window and got her gun out of her purse. And then she took that gun and she made sure she had a hot chamber. She already had a hot chamber. So she ejected an unfired round onto the floor, which was found at her feet by crime scene officers. And then she took her gun, and Zion explained to you that she pointed it at the window. And we know from Aaron's testimony and from Officer Darch's testimony that Aaron Dean was on the other side of that window in full police uniform, having been dispatched there by his department. And Zion Carr said, I thought I saw a badge. And Zion Carr said, the officer told her to put your hands up, show me your hands. And she didn't do that. And that's when the officer shot her.
She got an information about her birthday.
Well, the person?
By the window.
In her room or in a different room?
Her room.
Her room, okay. You said she got her weapon. Tell me about her weapon.
It was a gun, and she did the police shot her, and if she went up the gun, she was crying.
You said she got her gun and she pointed. Did you see her point the gun? Where was she pointing the gun?
At the window.
Did you see anything through the window?
Yeah.
Tell me what you saw.
I saw a gun out the window, and I got on top of the bed.
You think you saw a gun and maybe a badge, and then you saw one flashlight outside the window? Okay. Could you hear anything when you saw the flashlight?
Yeah.
Tell me what you heard.
He said, put your hands up.
Did you hear anything different than put your hands up?
He put his hands and gave her, put your hands up now.
To put your hands up, then you heard put your hands up now. Okay. And then what happened?
And then she did it too, and then they shot her.
Did
Because she was dead.
the glass assessment?
And then the police came in our front door.
They came to the front door.
The lady phone, police come in, police, and I said, I don't know what to do. She said, I'm not ready. And I said, well, I'm gonna lift it, and she didn't say nothing. She just told the other police who was from within. I'm not sure. She said, yes. Look.
That's tragic. It's tragic what happened. It's tragic that Zion saw it happen. But Zion saw enough to even know that it was the male officer, not the female officer, that had to shoot his aunt. That's what Aaron said. It's a mirror image of what Aaron Dean told you about what happened out there. And we know that it's true because that's what Zion said shortly after it happened. And that's what Aaron said happened out there that night. And the third eyewitness that you heard from about what happened out there was the body cam video. You heard Grant Fredericks, the expert from Spokane, Washington, who is an instructor at the FBI Academy and many other places about forensic video. He obtained what's called a first instance copy of that video. He compared the hash number of the video he received to the audit trail from Aaron's body-worn camera and ensured that he had the original video, the best copy he could get. And he interrogated it. And based upon his interrogation of the video, he came in here to court and told you what he saw on the video. And he saw the same things that Zion and Aaron saw. He saw the woman in the video, the woman on the other side of the window from Aaron, raising her arm with a dark object in her hand. The dark object, you know from the statement of Zion and the testimony of Aaron Dean, was Atatiana Jefferson's firearm. A deadly weapon. The kind of things that police officers are trained to deal with. You heard the term officer safety mentioned several times during trial. Fort Worth police officers spend a week in a school called officer survival so that they know how to deal with situations like this. And they also know how to deal with situations like this from their general orders. And their general orders tell them, based upon the law of the state of Texas, the law of the Supreme Court of the United States of America, the statutes of the state of Texas, the right to self-defense, the right to defend a third person, that they have the right and they should meet deadly force with deadly force. And you recall during jury selection, we asked you, does an officer have to wait until he's dead before he exercises his right of self-defense? Of course not. That's the whole reason we have a right of self-defense, is to defend ourselves. To make sure that no one uses a deadly weapon on us, to save our own lives, to save the life of a third person. That's why that law is on the books. And Aaron had the right to do that night. And that is unfortunately what he had to do. Several witnesses told you that police work is inherently dangerous work. It's a balancing of risks. Police officers go out every night and deal with situations like this. Fortunately, most of them do not involve the confluence and continuum of events that happened in this case that unfortunately led up to this situation. And you heard about what that situation was. Mr. Smith from across the street called the police. In his mind, he wanted them to go check on his neighbor. But that's not what he told them. He told them that there was an open door over there, and he wasn't sure what was going on. He told them about the cars parked in the driveway. Now, police have rigid rules about how they deal with that kind of situation. When someone calls the police take the information given in the call and they code it. And they dispatch their officers accordingly. And in this case, the buzzwords that Ms. Talbert, the call taker, heard was open structure. So Aaron and Carol were dispatched on signal 56, which in police jargon is an open structure call. And they are told in their general orders, generally, how they are to deal with an open structure call. And they went out there and they dealt with their open structure call. And you know from your experience as a citizen, that when police officers are called out on a call, they do what's necessary to do a proper investigation. And their proper investigation in dealing with an open door, an open structure, a silent alarm, whatever it might be, is they go check the structure. And checking the structure requires them to get on the property and have a look at it. And that's what Aaron and Carol did that night. Unfortunately, they did not get a chance to complete their investigation. You heard a lot of criticism of Aaron about how Aaron handled that call. A lot of Monday morning quarterbacking about how Aaron handled that call. Mr. Priest, that was called by the state of Texas to testify in this case, had all kinds of problems with how Aaron handled that call. He did all kinds of Monday morning quarterback. He quarterbacked all week on Aaron. What did we talk about with him? He'd come out here and talk about, well, I didn't like the way they crossed the intersection. They crossed the intersection and they could have been seen by someone, and they're not supposed to do it that way, and that's bad policing, and gee, that's just sorry. That's just sorry work. And he had all kinds of reports to review, and he said he did all kinds of work and didn't take any notes, but by God, he remembered everything and understood it all. And really, all he had to do was go ask Mr. Smith about crossing that intersection, what that was all about. Because Mr. Smith took the witness stand here and told you, it was completely dark out there that night. Completely dark. Mr. Smith testified that he and some of his other family members were sitting out on a porch across the street. And Mr. Smith had called the police, and he was expecting them to show up, and he was watching for them. And all he saw were two silhouettes. And he was looking for that, paying attention for it. Aaron got criticized for not seeing him on the porch across the street, on a completely dark street. Then he got criticized for going up to the door and not announcing himself. Then he got criticized for walking around to the back and looking at the back. The general orders call for an investigation. You have a look at the structure. Figure out what's going on. Then start making decisions. If Aaron had walked up to the front and announced himself, and there had been a burglar in the house, what the burglar would have done? Go out the back, of course. You can't have it all those different ways. You can't be wrong about staying at the front. You can't be wrong about going to the back, or vice versa. It's like the old trick with a balloon. You squeeze one end of the balloon, the air all goes to the other. You squeeze the other end, it goes back. It's simple. You go out there and do the best you can. And snipers' nests, we talked about that, and I don't know. I don't know how we got that far off of reality, but we did. But they were out there doing an investigation. And Mr. Priest criticized Aaron for not checking the deck lids on the cars. Like what? A burglar crawls in the trunk of the car and hides out waiting for the police? Now, come on. That doesn't happen. But then Mr. Priest forgot about something. He forgot that several years ago, he worked on a very, very, very similar case in Fort Worth, where a man was shot by Fort Worth police officers in his own garage. Police had been dispatched out there on an alarm call and went to the wrong house. The garage they shot the man in was the wrong garage. It wasn't the garage of the house they were supposed to be at. And the man didn't put down his weapon, and he was shot by the police. And Mr. Priest under those mirror circumstances, said that was justified. Uniformed police officer shot a man in his own garage, and that was justified. But he wants to pick apart and nitpick Aaron for what he did out there that night. Oh yeah. What's the difference? Money. He got paid to be here to say those things. But he forgot about that other opinion. I don't expect we'll be seeing Mr. Priest around here for a while. He's kind of worn out his welcome here, I always expect at this point. But he also told you after that police work's inherently dangerous. He told you that he was asked, do officers deviate from general orders? You know what his answer was? Of course. He also agreed you don't have to necessarily announce yourself at a silent alarm. Things changed after he was confronted with his inconsistent opinion on another very similar case. Sometimes when officers usually use deadly force, they say nothing. Because there's no requirement under the law before you exercise your right of self-defense that you say anything or do anything else other than exercise your right. And officers have to make those split-second decisions. And they have to decide like that if they're being threatened sufficiently to exercise their right of deadly force or their right to defend a third person. And that's how fast this case went. Mr. Priest had all kinds of problems with how Aaron handled that call, but in the final analysis, when Miles asked him about the actual event of firing the shot, he didn't differ with what Grant Fredericks had said about the timeline and about the right of self-defense. The only thing he wanted to quibble about was he didn't have any evidence to back up that there was a firearm there. But he hadn't apparently reviewed the recording of Zion and hadn't paid much attention to the testimony of Aaron Dean because there was a firearm. Those three eyewitnesses agreed on that. The firearm was pointed at Aaron Dean. A firearm is a deadly weapon. A firearm is the kind of thing that we're allowed to use deadly force to defend ourselves against. Police work is inherently dangerous work. You heard that from several witnesses on the witness stand. Pointing a gun, a firearm, at another human being is an aggressive, provocative act. And it's an aggressive, provocative act that draws a response of self-defense in defense of a third person. Aaron's actions that evening were justified under the law of the state of Texas. Aaron was a police officer in full uniform. You saw the photographs of him. He had Fort Worth PD, FWPD across his watch cap. He had distinctive patches on both shoulders. He was wearing a badge on his chest, a distinctive uniform. And when he's wearing a distinctive uniform like that, when any officer is, they have a right, a reasonable right, to expect that members of the public understand that they are a police officer and that they are protected from aggressive, violent, provocative acts of other citizens. They have enough to worry about out there on their job. Aaron got there that evening because He was a Fort Worth police officer. He went to the academy. He was trained. He graduated. He was issued a badge and a firearm, trained some more, sent out onto the street. When Mr. Smith called Fort Worth Police Department to report the neighbor's doors being open, Aaron was dispatched out there on that call. He was sent out there by his department to do a job. And the job was to check that building, check that residence, under the general orders, and see what they had. No one knew what they had. Mr. Smith, you recall, said he didn't go over there himself. He didn't go up to the house and knock on the door. He didn't go holler out to the neighbors to see what was wrong. He didn't go past the car, past the back bumper of the car that was parked in that driveway. Why not? What did he tell you? Because he didn't have a weapon. He could have walked up to that door and knocked. He could have hollered out to the residents, "Hey, Mrs. Carr, hey, anybody in there, everything okay? Front door's been open for hours. I've never seen your front door open before." He didn't do that. And he told you the reason was he didn't have a weapon. So he relied on the Fort Worth Police Department to go over there. And everybody in the world knows the Fort Worth Police Department carries a weapon. Every one of them.
You have 10 minutes.
Thank you. You know from what you heard from the Tarrant County Medical Examiner's Office, Dr. I can't remember if it's Fries or Fries, but it's F-R-I-E-S. He told you that Ms. Jefferson had glass stippling, pseudo-stippling on her face. She had a gunshot wound in her upper chest area, a fatal gunshot wound that he said would have killed her if she'd been shot like that in a level 1 trauma center. No one was going to be able to save her out there in that house. That's a tragic fact, but it's a fact. So when Aaron's criticized for running in too fast and not clearing the rooms to get to her, but then yet at the same time criticized for not getting to her quickly enough to render medical aid, that medical aid, unfortunately, would not have mattered that night. But we also heard from Dr. Fries, that Miss Jefferson, relative to where the shot came from, was in a slightly bladed stance, with her right turned slightly to her right. And if the shot went from up to down, left to right, went in up here, came out down here. Didn't come out, but lodged down in her lower back on her right side. After he saw that there was an error in his autopsy report. Because that's how she was situated when she was shot. She didn't have any pseudo-stippling on her hands because her hands were out in front of her, closest to the window, underneath where that cone of glass entered the room. The medical examiner's testimony mirrors the testimony of Zion and Aaron and Grant Fredericks, because the position is correct. It all fits together, ladies and gentlemen. It all fits together. And from Aaron's standpoint, which is how you are to judge his reasonableness that evening, he saw a firearm pointed at him, and based upon his training, he reacted. He reacted tragically, but he reacted correctly under the law. The state cannot prove to you beyond a reasonable doubt that this was not self-defense. They cannot prove to you beyond a reasonable doubt it was not defense of a third person, because it was. He reasonably believed that his actions, his deadly force, was immediately necessary to counter her use of unlawful deadly force, because it is always against the law to point a handgun at a uniformed police officer. And that's what happened here. It's tragic, but it's not an offense under the laws of the state of Texas. The jury charge contains verdict forms at the end. The proper jury verdict form for your use is the top one, which says, "We, the jury, find the defendant, Aaron York Dean, not guilty." He's not guilty because he validly exercised his right of self-defense on that occasion. And he validly and reasonably exercised his right to defend a third person, that being Carol Darch, who he had every reason to believe, based upon training and experience, was going to be right behind him where her training told her she needed to be. And she was. And she was in the line of fire, just the same as Aaron Dean was. So, nothing that we do here this week is ever going to bring Miss Jefferson back, unfortunately. Nothing can change that. But by the same token, the tragedy should not be compounded by finding guilty a man who is relying on his rights as a police officer and his rights under the laws of the state of Texas. We would ask you to find Mr. Dean not guilty of these charges. Thank you very much for the time and the attention that you've given me this morning.
Mr. Smith.
May I have a moment, Your Honor?
Yes, sir.
Before I get started?
That's perfect.
Police court.
Yes, sir.
Defense counsels. Ladies and gentlemen of the jury. I guess it's inherently dangerous to sit in your own bedroom, in your own home, in the middle of the night, while you're babysitting your 8-year-old nephew. Because she's the one that's dead, not the defendant. And all this talk about training and self-defense, it's not the defendant's point of view. You will not see anywhere in this charge that you're to look at it from the defendant's point of view. You're to look at it from a reasonable person in the same circumstances. Well, you know who was in the same circumstances as the defendant, who was looking death in the eye? That was Atatiana. Did she fire? No. He did. And we're going to talk about it here in a minute. You're going to see that he didn't even see a gun. But let's talk about how we got there on October 12th, 2019. Because let me tell you, the one person that had no input on any choices that night was Atatiana Jefferson. Not one choice as things unfolded. Because on October 12th, 2019, when the defendant was called to her house, he was the one making choices. When he approached that front door, he could have knocked and Atatiana would still be alive. When he approached that front door, he could have said, Fort Worth Police, and Atatiana would still be alive. The general orders are here for a reason. They're here to guide these officers so they get home safely and the citizens of Tarrant County of Fort Worth are protected and served. Atatiana Jefferson was not protected or served on October 12, 2019. The defendant's own words. They want to argue about Dr. Priest, or Mr. Priest, or Dr. Coons. Dr. Coons couldn't answer a question. If I would have asked him if the sky was blue, he would have said, maybe, perhaps, there are other factors. The man couldn't answer one straight question. What does that say about his credibility? The defense's witness wouldn't even answer one question after he saw the defendant time and time again sitting in that seat, look at you under oath and say, that was some bad police work. That was some bad police work. Dr. Coons watched him admit bad police work over and over again, then stood up here and told you he did everything great. The defendant knew he didn't do everything the right way. And when you look at the general orders for silent alarms, because that's what you can look at, it's in the exhibits. It says, if you see signs of damaged entry, you shall call for backup. What did the defendant tell you on Monday? I thought the window had been, the screen door, there was damage. Someone had broken in. There was a screwdriver right next to the door. That's signs of forced entry. Signs of forced entry. His general orders say it. Signs of forced entry, you shall call for backup. But he ignored that. Because, you see, you know who the defendant really is as he testified. You know. I mean, he cracked a joke. I guess I just should have stayed home that night. Someone lost their life. He's supposed to be testifying in his own defense, and he's cracking jokes from the witness stand. I guess I should have just stayed home that night. Well, Atatiana was home, and she's no longer here because of what he did. The choices he made, the choices that she had no input into. She, the defendant, did not call for backup when he saw that second screen door, even though it was in his general orders to do it, shall do it. So he kept going, because that's who he is. Gung-ho, hard charger. Ignoring his own safety, ignoring Officer Darch's safety, he leads her into that backyard. And I guess Dr. Coon says if you don't want the police in your backyard, you better lock your gate. All of Fort Worth better go lock your gates right now, or I guess the police can just go in your backyard whenever they want to. Or was that as ridiculous to y'all as it was to me? We have a reasonable expectation of privacy in our homes, just like Ashley talked about. Just like you know, home is where you feel safest. Home is where you know you can protect your family. Home is where you know you can care for your nephew while your mother's in the hospital. But the defendant didn't care about any of that. He was going to get in that backyard. Regardless of that front entryway being completely open, anyone that was in that house could have taken off running. Anyone in that house could have come back around and shot him in the back. He wouldn't have known it because he didn't care. He didn't care about the general orders. He doesn't care about who's in that house. He's a hard charger. He is gung-ho. He was going to get in that backyard. And Atatiana's sitting there playing video games, watching Zion, knowing that this defendant is making life-ending decisions, and she can't do anything about it because she has no idea. So now they get to the gate, and he opens the gate, and they get inside, and they get to that back window. He'd been shining his flashlights all over the cars, shining his flashlight in the back window. Now, again, it's a reasonable person, but I want each of you to think, what would you do in the middle of the night if you heard a noise in your backyard? And your children, your grandchildren, nieces or nephews, whoever it may be, are there with you. And you know that you are the only line of defense for their protection. And you hear that noise, and you see a flashlight in your backyard, and you know that you have a gate and a fence that's protecting your backyard. What would you do? You would do the same thing that Atatiana did. She's in her own home. She sees somebody she doesn't know in that backyard. Zion's on that bed. And she knows that she's the only person that can protect Zion from what's happening in that backyard, because don't forget, she had no idea what decisions the defendant had made up to that point. So yes, she gets her gun, and she goes to that back window and looks. And they want to make a big deal about Mr. Priest. That case, that man was given commands, and that man had the opportunity to observe those commands, and that man did not. I want you to remember how long their video expert said was from the beginning of the command to the shot was fired. Half a second. How was she supposed to comply? What was she supposed to do? And pointing a gun at a Fort Worth officer is illegal? Yes, it is. If you're violating the law. She didn't know who was out there. She didn't call the police, and she had no input on any decision he had made up to that point. She was there to protect Zion, and that is all. Her only crime was love and protection of her nephew, not pointing a firearm at the Fort Worth Police Department. So he's at the window, and you watch it. Take the body cam back. Watch it over and over again. Look at the audio. Half a second from the first command to where, and it's put up your hand, show me, bam. Half a second. No one can comply with that. No one. She never had a chance. She never had a chance. There was nothing she could do. Nothing that she could have done could have changed what was going to happen, because that man decided when he got to that home that he was going to be a hard charger, he was going to be gung-ho, and he was going to take command of this situation. All while she's just there trying to protect Zion. And she died at his hands. So now we're at the window. And they brought this videographer guy in here and all this other stuff. But let me tell you, there's a lot of evidence that shows this man never saw that gun. He didn't know what he saw. He just shot. He didn't shoot 2 or 3 times to make sure that the threat was over with. He shot 1 time. And their expert, one trial, he's saying it takes a second, a third, a second and a half for the brain to make a decision and for your hand to react. But no, this one's different. This one's different because it's a different case. Or is it because it's a different legal theory? I'll switch it up for whatever the defendant needs. But regardless of that, you know that she didn't have that gun up, because I want you to remember, as the defense attorney questioned Dr. Freeze, we talked about the cone of glass. Now I'm way out here, State's Exhibit 38, 39, 40, 41, 42, 43, 71, 72, 73, 74, and 75. Those are her hands, folks. When the defense attorney gave his argument just a minute ago, he held his hands up like this. If her hands were in front of her face, they would have been hit with glass. They would have been hit with glass, and you would have saw the same injuries on her hands and forearms as you would have saw on her face. They're not there. You know why? Because the gun was down. Because she didn't know what she was looking at. The defendant testified she was bent over almost perpendicular to the ground. And then the videographer said she's up straight. Well, she couldn't have been up straight if the bullet enters here, like the defense attorney just said, and is found down lower just past her right kidney in the back. She was bent over. And Zion testified the gun was in her right hand. Use your common sense. You didn't lose it whenever you walked to those metal detectors. How must she have been standing? She's standing like this. If she would have had the gun up like this, she would have had glass. If she had the gun in her hand, it was down. He didn't know what he saw. And where's the green laser you were promised last week in opening statements from defense attorneys? I want you to remember, the defense attorney stood up, looked you in the eye, and said, you will hear testimony that that green laser hit his chest. Not one person from the witness stand, including the defendant, was able to tell you under oath that that green light hit his chest. You know why? Because he didn't see it. So why did they tell you that in opening statement? Ask yourself, why? I think you know. But then, remember what we talked about in jury selection? You can infer things from people's actions. So now, let's take a look at what happened after he pulled that trigger. Because I tell you, what he did after he pulled that trigger shows you, beyond a reasonable doubt, that he committed murder and that he didn't see that gun. He didn't know what he saw. He saw a silhouette.
Argument, because the jury's job is to view this case from the standpoint, according to the charge, of a reasonable and prudent person at the time, not in hindsight.
The jury has been instructed. Your objection is overruled.
He didn't know what he saw. And you're going to hear it here just in a minute as I explain it, because you probably already know. You know because you heard the testimony when he saw this silhouette, and you can take into account what he did afterwards as evidence of what he knew.
You may.
You can take into account what he did afterwards as to what his intention was at the minute, the second he pulled that trigger, that half second. There's nothing that says you can't, because it shows you what he was thinking as he pulled that trigger. At first, he just stands around. There's no other shots. If there was a real threat inside that window, do you think he would have just sat in front of the window? Do you think he might have pushed darts out of the way, got back, retreated to another position? No, he's standing there because he wasn't sure what was on the other side of that window where he just shot. He wasn't sure. And then, as they start moving, Officer Dart says, we got to get in there. Does the defendant say, Officer Darts, you need to know there were people inside that house with a gun? He doesn't. He lets his partner officer, a good Fort Worth officer, run into that house without telling her there's a gun. What officer would allow one of his partners to run into a house where they thought a burglary was happening without saying, hey, there's a gun in there? Gun, gun, gun. Defense attorney wants to talk about inherently dangerous. He let Officer Darts walk into a potential lion's den without giving her one heads up. You know why? Because he wasn't sure what he saw. Then, as they're checking the doors of each room of that home, they go peeking in each room. Quick peek, quick peek. They're not clearing the rooms. They're not clearing the rooms. They didn't even check the bathroom. They're not clearing the rooms. And you know why they're not clearing the rooms? Because the defendant never told Officer Darts there was a gun. Officer Darts is just trying to get inside whoever was shot. He never said there was a gun because he didn't know. And then when they finally get back to the bedroom, and Officer Darts grabs Zion up and takes him, the defendant walks over to Tatiana, taking her last breaths. And as she's dying in front of him, he doesn't lean over and give her aid. He doesn't comfort her in any way. He doesn't try and stop the bleeding. He looks down between her legs, kicks something, and says, see what looks like a weapon here. Not, there's the gun. Not, here's the gun. Not darts, we've got the gun. Looks like we have a weapon here. And that sigh you hear that the defense's expert tried to say was a sigh of relief, was a sigh that he just got of danger? No, that was a sigh of relief. Looks like we have a weapon here. That is not a declaration of a person that was sure of what they saw. Because he didn't know when he pulled that trigger. Looks like we have a weapon here. That's how you know that self-defense doesn't apply to this case. That's how you know that we have proven beyond a reasonable doubt that the defendant was not acting in self-defense, because Atatiana was not acting unlawfully. She would have to be acting unlawfully for the defendant to get the benefit of self-defense. And again, what is unlawful about protecting your nephew and protecting your home? Even the defense's own witnesses all agreed what she did was not unreasonable. And again, you'll never see it in the court's charge. You can look through every page. It's not from what the defendant sees. It's from what a reasonable, prudent person sees in the same circumstances. And I tell you right now, no reasonable and prudent Fort Worth officer would have gone hard charging, gung-ho, past those two doors, into that backyard, creating a situation of danger for not only himself, his partner, and anyone in that home. Because he's the one that made the decisions on October 12, 2019. He's the one that ended Atatiana Jefferson's life, and he's the reason that we are here. This is a matter of accountability. Tragedy, an accident, that's spilling your milk at breakfast. This is murder. Someone lost her life. Atatiana is no longer here through no fault of her own. And now you're going to decide if someone's going to be held accountable or not. And you're going to have to look deep inside and look at this evidence. And you know, he never saw that gun. He didn't know what he saw. He was hard charging. He was gung-ho. He finally got some action. And he was going to pull his weapon. And because of that, Atatiana will never breathe again. And because of that, Zion no longer has an aunt. Because of that, two sisters and a brother no longer have a sister. And that's not okay. So go back there and do what you know is right and find the defendant guilty.
Mr. Smith, before I excuse the jury, would you remove the exhibits from the record?
Yes, Your Honor.
Thank you. All right, up until this point, you've been unable to discuss the case amongst yourselves, but that restriction is now lifted. Retire to your jury room, select a presiding juror, let me know if you need anything.
Okay. 12 and 2?
Yeah, yes. Hey. No, we'll look at it. Yeah. We'll be in.
Wow, Aaron.
Woo!
That was on fire.
That's really good.
A tragedy,
An
or
accident.
an accident. That's spilling your milk at breakfast. I mean,
Yeah.
like, that's wow. So let's. But before let's go back to kind of the beginning of these closing arguments. We were talking about some of the point that Ashley Diener made that you really thought was important. Let's walk through that.
So the prosecutor who opened the close, Ashley, so she started off talking about the sanctity of your home and how sacred that is. And at the beginning, she got me interested because it was very passionate and compelling. Right. She was really honed in on his preconceived notions about the neighborhood and how, the east side should be protected like the west side, like the north side, all that. And that all felt sort of, dramatic and interesting. But then she kind of got real serious real fast when she got to the charge, and she started talking about how the only way he's justified is Atatiana's use of force was unlawful.
Why is that key?
Because I don't know that we can all agree. We can't all agree on anything, but if you look at Atatiana, 20-something-year-old aunt of 8-year-old child, late at night, playing video games, airing out the house after the burger burn, just playing, scary noises in the backyard, a little bit of panic, a little bit of fear. She goes to get her gun. She points at the window. Totally fine, totally justified, not unlawful. She's absolutely allowed to arm herself in her home. So what she was doing was not unlawful. And if that's the case, and if we all agree that she was not acting unlawfully, then Dean doesn't have self-defense, period. He even if the jury believes he acted to protect his own life, he did not use deadly force against the other's use or attempted use of unlawful deadly force.
So key words.
Key word, unlawful. If Atatiana was acting lawfully, which arguably in her own home,
she had a concealed. She's perfectly within her rights to have that weapon.
Then he doesn't even get self-defense on the law. So I thought that was the critical part of Ashley's argument. She also made a lot of really good points about the preconceived notions. She made really good points about the sanctity of our homes being compromised. She made some really good points about power, which I feel like her co-counsel came back to, but we'll come back to that. Talking about how power can corrupt, and then she beautifully closed it with, and now you, the members of the jury, have the power, and what are you going to do with it?
Yeah, she says, we know what he does with power. What are you guys going to do with it? Find him guilty. And I underlined that because I thought it was pretty powerful.
And I hope what she meant was, we know what he does with power, bam. But what are y'all going to do? Stop, think, read, apply. I mean, I think that's what she was trying to suggest was, why don't you be thoughtful with your power? And then she wants them to do the right thing. And anyway, but I really do feel like the most important part of her argument was how she focused
that's on the law.
On the charge. Yeah. And I told you while we were listening, I whispered, ooh, and maybe I'm hodgepodging, but I sure hope there's an engineer on that jury. If I'm Ashley Diener, I want somebody on that jury who is going to be ticky-tacky on the words and see that and be like, oh, well, I was thinking that the officer was justified because he shot at what he thought was an armed individual fixing to shoot him, right? But even I'm saying, let's say the juror believes that, and they're like, oh, I think it was justified because he shot at what he thought was an armed person fixing to shoot him. But if the armed person fixing to shoot him was acting within her lawful rights,
right,
then he doesn't get the justification on the law. So when I whispered that I thought Ashley might like for there to be an engineer on the jury, I meant somebody who was going to really hone in on that one tiny word and then and rely on it.
Well, like I said, I thought that was very interesting because that was not a point I had really thought about, when you look at those words. And of course, we didn't know really exactly what was going to be in the jury charge until today.
Well, to be fair, we didn't, but we do because self-defense is plain as day in the code. And if you look at the justifications in the penal code, plain as day. You can use deadly force when and to the degree reasonably necessary to prevent the other person's unlawful use of deadly force against you. I'm not saying it verbatim,
Did you memorize that in law school?
When you hear it so many times, I mean, I've worked on so many self-defense and defensive third-party cases. In fact, I just worked on a really important one where a young woman used defensive third-party, defensive self, unknowing at the time, but she used deadly force to protect the life of herself and her baby.
Did you win?
The district attorney's office dismissed the case. They did the right thing. My point is, it's recent. I've just been working on it, and I've worked on it numerous times, and so yeah, you do memorize that. Yeah, went into the degree reasonably necessary. The OPP, the ordinary prudent person, that's what we used to call it in law school, was the OPP, the ordinary prudent person, because that is the reasonable standard. And I do feel like all three lawyers, Ashley for the state, Dale for the state, and Bob for the defense, they all tried to touch on that reasonable part. And of course, Dale Smith really got it, because he said, who's the ordinary prudent person in the same circumstances? Atatiana Jefferson.
Right. Wow.
Yeah.
So before we talk about Dale, because
Right.
I guess I'm kind of going chronological here for
Good.
my notes. Let's talk about Bob Gill. Bob is a longtime attorney. He was a judge for many years. I mean, he's a very, both him and Miles Brissett, the other defense attorney, are very good attorneys, very good at their jobs. What did you think of what he had to say during his closing?
Well, so, he started out with humility, and he tried to appeal to the jury that he was grateful for their service and their attention, and that he paid attention to them paying attention, which I feel like might really kind of get the attention of a couple of the jurors. But at the same time, what I think he was trying to do was say, hey, I know you've got my client's life in your hands, and I don't take that lightly.
Right.
He tried to say that Atatiana Jefferson
committed a crime.
Yeah, not acting within her rights. That she was, I'm pretty sure he cited the penal code. I'm pretty sure he said that she was committing an offense.
He said she had those rights up until the point up until she pointed a gun at a Fort Worth police officer. It is a crime.
And I don't know that there was any. I was not in the courtroom for the entire case. I've tried to consume as much as I could, but I don't know that there was any corroborated or uncontroverted testimony or evidence that suggests that at any moment Atatiana Jefferson had any knowledge that there was
dead, so
police in her backyard. Yeah.
Yeah, and again, it's key to note that he does not announce himself, and and it's very dark out there. I mean,
Right.
by his own testimony, it's very dark, and he says he saw a silhouette, and I'm sure that
she saw a silhouette.
A silhouette too, yeah, thinking it's probably a burglar. So, and if she thinks she sees a burglar, then she's within her rights.
Right, but the way that Bob Gill said it, Bob Gill said she did not act within her rights when she pointed a gun at an officer. But she would have had to have known it was an officer in order for her behavior to be criminal, or, to use the words of the charge, unlawful. So I don't know. I don't know that the jury can consider her behavior unlawful. It stands to reason that maybe everybody can agree she was within her right to have a gun at her window when she thought there was a prowler, a criminal, a murderer, a rapist, an intruder. Of course she's going to have a gun.
Right.
And so, what did you think about when Gill showed the forensic interview of the young boy, the nephew?
I think it's really dicey to come out. Let me look back in my notes.
Oh, you focused on how he said, yeah.
Yeah, but when he basically said that, he testified differently from the truth. I don't know if I would have gone. I mean, I'm not a lawyer, but.
I think what he wanted,
that's a tough one. I mean, you and I kind of looked at each other like, ooh.
Well, because I think he wanted to point out that the child testified differently than he originally had commented. Yeah,
right. His original interviews right after this, but I always find it interesting that. So we're gonna put all this burden on this. At the time, he was an 8-year-old. Now he's an 11-year-old, right? Yet police officers this is a routine thing in law enforcement. They want between 48 and 72 hours because they say, memory is a funny thing and we need more time. And there is some research behind that. But the 8-year-old gave a statement at the time. Aaron Dean did not.
Correct.
So he's had 3 years for his to come up with what he was going to say.
You mean Aaron Dean has had?
I'm sorry, Aaron Dean, yes.
Right, because I don't think that child has sat around for 3 years to think about what am I going to say when I go to court about that day when my aunt got shot.
And maybe his testimony was influenced. I don't know. I think it's a dicey thing to it's a real fine line there. And
probably Bob Gill wanted to point out. Probably Bob Gill was trying to convey, and maybe did convey effectively to some jurors, that the child's statements in the forensic interview were the statements to be relied upon.
And I could definitely see why you would want to make that argument, because the original statement is much more in keeping with what Aaron Dean wants the jury to believe.
And what Aaron Dean told the jury in his sworn testimony.
Right, because in Zion's original forensic interview, he also describes seeing what he thought was a badge. So you could see why the defense would want him to for that testimony to be relied upon. And I will say that when Zion was the first witness on the first day of the trial, and both sides were caught off guard when his testimony was different. I mean, it was clear both sides were like, "Whoa, okay, wait a minute," and so
was different than what he originally said in the forensic interview.
Yes,
but to say that one is different from the truth, or that the truth is different from the other, it did sort of sound like the defense attorney for Aaron Dean was accusing the boy of lying, whereas maybe what his intent was to show that the boy's truth, closer in time to the offense, or closer in time to the tragedy, or closer.
It should be more relied upon.
Maybe so.
To me, that's kind of
right,
more reasonable. So let's talk about I'm just going to go through he says what else. So he points out that the body cam, he says that Bob says that that the body, he's saying that the body cam backs up what Aaron's saying, that what Zion says, and that there's a woman on the video, or a person, a figure on the video raising her arm with a dark object, but in her hand, that kind of thing. And then he basically goes on to say that pointing a firearm is an aggressive, provocative act, and that draws a response. But how effective did you think his arguments were to the jury?
Hard to say. I guess we'll see. But I will, just to touch on the point where you noticed that Bob Gill called her behavior provocative.
Right.
For me, but as a practitioner, that immediately made me think of what assaultive conduct is under the penal code in Texas. It's actually a Class C misdemeanor assault to speak with provocative or offensive behavior, or to create a provocative or offensive contact or conduct against another person. And not that anybody else was picking up on that. But my what I was thinking was that maybe he was trying to establish, in my mind, that she was unlawful, that her behavior was unlawful. And so Aaron Dean's response, coupled with the presence of the gun, Aaron Dean's response would have been justified.
He says he saw a firearm pointed at him, and based on his training, he reacted. He reacted tragically, but he reacted correctly. That's what Bob said.
Well, Aaron Dean's going to think he acted correctly because Aaron Dean saved his own life, according to Aaron Dean. Today, looking back, but we don't know. We don't know whether he acted correctly. I mean, the jury's going to tell us what they think. Mm-hmm. Bob Gill thinks his client acted correctly, but if the jury doesn't know for sure, or isn't compelled beyond a reasonable doubt to believe that Atatiana Jefferson knew those were officers, and if the jury follows the law to a T, as Ashley pointed it out, then Miss Jefferson was not acting unlawfully, and Aaron Dean could not have legally used just deadly force against her. Police officer layperson, he would not have been justified.
So right now, if you were sitting on this jury, you would vote to convict Aaron Dean of murder.
I feel like because of the language in the charge, yes. But wait.
And you're a lawyer. I expect nothing else.
Well, but hold on. What if I put everything Ashley Diener said aside? What if I didn't catch on to that little nugget in the incredibly important nugget in the charge that maybe the defense hopes
the jury
doesn't go with? If it put all that aside and think about what that other lawyer for the state said, Dale Smith, his argument would have me believe it doesn't even matter what the charge says about unlawful or lawful or deadly force or self-defense, because Aaron Dean, the hard charger, the gung-ho officer, finally got some action, and he just went in there and he just went guns a-blazing and he
Dirty
just
Harry.
shot, to kill. And justifications don't even come into play, according to the way Dale argued the case. So that was pretty brilliant that the government or the state decided to do both. I mean, they open with this nugget of law, you better rely on this, and then they close with it's just straight murder.
Yeah, and he also kind of got on to, brought up that, Dean had, during his testimony, had talked about how had made a kind of, maybe it was a nervous joke or whatever it was. I could have just stayed home that night, but he came back to that and said, brought that back up.
You mean Dale Smith did?
I'm sorry, Dale Smith brought that back up
about Dean's testimony.
Yeah, which is also why I'm sure when you prep a witness, you're like, probably whatever you do.
Yeah,
don't get frustrated. Funny. Yeah, there's nothing funny. Don't
try to be cute. Don't try to punt. And I don't know. I don't remember the series of questions that led up to that response from Dean. I don't know if it was frustration.
It was either in the original cross or in I forget. It came pretty late, but I mean he was clearly frustrated.
So it was kind of like, well,
I guess I
just should have stayed home. Yeah. I mean, maybe that's what he was trying to paint the picture.
Yeah,
Mr. Smith, the prosecutor.
Yeah, it was after he had it kind of repeatedly acknowledged bad police work. Again, bad police work doesn't necessarily add up to criminality.
But by the way, none of the arguments had anything to do with. Well, they did. They had everything to do with whether Dean was right or not right and how he approached the call. But what they didn't do was, it didn't seem like anybody tried to establish that Dean was not legally entitled to use deadly force because he was engaged in criminal behavior. They didn't even go there. So I don't even think what we talked about earlier is going to be as big of a deal for these jurors as we thought it would be. You know what I mean?
Right.
Because I don't think that anyone tried to suggest that his bad police work rendered him a criminal trespasser who therefore doesn't have the right to use force because of his unlawful behavior.
Call Rebecca?
Well, we'll call Rebecca in a second. And definitely, I just want to kind of finish. We're kind of still working our way through these openings, these closings. Sorry. And then I also, I kind of underlined the parts of what was said that I liked. We said, Dale said, "What would you do if you heard a noise in the middle of the night? You would do the same as Atatiana did." I kind of like that. And then I also liked that he brought up that she had a half a second.
Which really didn't you remember that the expert made it seem like just even less? Which it's really hard to quantify.
But I mean, a half a second is
not even anything. Yeah.
I mean, I don't even know. It's hard to even show that. It's so fast.
So, if she had had a half a second or 1 second or a second and a half or 2 seconds to either acknowledge the officer, respond to the officer, drop the weapon, he wants us to believe that the weapon was up, so put down the weapon. If there had been another half second, another 2 seconds, then she would no longer have been armed. And then he would have not shot his weapon.
Right.
It sounded like his "show me your hands" and the shot fired, they almost sounded contemporaneous.
Yeah.
Yeah.
Yeah, and there was some testimony about how the act of pulling back the trigger and the time that it would take for the shot to be fired, that it would have been pretty much contemporaneous, yeah. He also said her only crime was love and protection of her nephew. Thought that was pretty powerful.
Dale Smith, yeah.
Yeah, I mean, there was a lot of stuff that I thought was pretty powerful. Now, of course, I don't know. The jury they may, they might not take, they might see it very differently. It's really hard to, it's always, difficult.
Yes, and if you've got a no-nonsense juror who doesn't want fire and brimstone or passion or volume, and if you've got a juror who wants a kind of a dry, clinical argument because the juror wants to decide what's passion-worthy and what's volume-worthy, still, if you take out the passion and you think about what Ashley honed in on with that little nugget of law, the jury may have no choice but to convict, unless someone on the jury says, I believe that Atatiana Jefferson was acting unlawfully when she had a gun at the window, pointed a gun out the window, whatever it is that they believe.
But Dean's attorneys, they only need one.
Meaning one juror?
One juror.
With one doubt.
One doubt,
That's
one
right.
juror, one doubt.
Not to achieve
hang
an
it up.
acquittal, but
Right.
to hang it up. Agree. Mm-hmm.
Oh, somebody's asking me what if I was on the jury. Well, I'm not going to offer.
You asked me.
I know.
Oh, that's fair.
I know.
Fair.
It's just, because I go all the way around the world on these things.
Well,
like,
and I'm going all the way around the world right this second, thinking that maybe Aaron Dean was justified. Maybe he went to the degree reasonably necessary. He had to fire that weapon right there because he was deadly force facing deadly force. But I'm saying, even if that was his belief, and even if that was the ordinary, prudent person, reasonable standard, and all of that, check all those boxes, the fact that Atatiana Jefferson was not using unlawful force just obliterates the justification, and it takes it away.
And that takes me back to Geiger. Because remember in the Geiger case, I'm sure all you folks out there in YouTube jury land were also paying attention to that case, because remember in that case they argued mistake of fact.
Right.
And that she believed she was facing an intruder. And so she therefore was reasonable. That was what her defense argued, that she was reasonable in her actions to shoot both of them, Jean. And basically the jury said, no, she wasn't reasonable. Shouldn't have gone in there, and they convicted her.
They didn't go with it.
They didn't go with it. I mean, now, of course, it's a little different because both
no,
of them
it is.
wasn't.
But the question is, but it's different, but the same, but totally different. But did Atatiana Jefferson, was she within her rights, to use Gil's words, in the moment she had the gun facing out the window? And honestly, even if she knew as an officer and she didn't have that nanosecond to remove her force, I still don't know if you can call that unlawful. I still don't know if anything was unlawful about her and the gun in that moment. So the other thing, Dale Smith for the state pointed out in his closing argument, he focused on Aaron Dean's actions after the shooting. And you notice the defense objected and tried to shut that down, but the judge allowed the argument, and Smith went on to argue that Aaron Dean, upon locating Ms. Jefferson on the ground dying, sees the gun, and the way he sighed and the words he used indicated not confirmation of something he already knew, but more like a surprise or relief.
Like, thank God I found it.
Yeah, or thank God I found something.
Says, looks like we have a weapon here. Sigh.
But could that have been him saying,
it's hard to say.
Looks like the weapon, like, oh God, or maybe even,
or it could also be like,
I was right. God, she was armed. Oh, it could have been despair, relief, regret. It could have been any of those things.
Yeah, I mean, exactly. I mean, it's hard to read into those statements, but it is an interesting thing to say.
Well, it was a
because it's the first mention of a weapon
by Dean at the scene
is when he gets in the house and he gets in that bedroom.
Because Dale Smith also pointed out that as Dean and his partner make it through the house and they peek and they peek and they peek, still at no point and that was probably also based on the female officer's testimony. At no point does Dean alert his partner that there was a gun. Now, it could go without saying there was a gun because that's why Dean discharged his weapon.
Mm-hmm.
So maybe we are not taking that for granted, or we are taking that for granted. But
so some people think you're biased.
In which direction?
I guess they think you're biased against Dean.
Well, so need I remind YouTube land that moments ago I said I'm going around the world on this in one moment, because what if I think Dean was justified and he met deadly force with deadly force? But what if he doesn't get to on the law because Atatiana Jefferson was allowed to have her gun inside her house at night, scared, uncertain? What if that was a lawful use of force on her part? Then it doesn't matter if I believe Dean or not. I can believe him all day long that he acted.
It doesn't matter.
It won't matter, because if she didn't have an unlawful show of force, then he can't be justified.
Right.
Right?
It'll be interesting to see. I would be very curious to know, like, the reasoning that these jurors use one way or the other.
Before we go off that, when we pick juries, and when we are doing jury selection and we try to poll the panel on how they feel about law enforcement, I will use this example. I remember it was on a murder case, and I'm polling, it was an aggravated assault public servant case. I represented a guy who showed a weapon through the door at some officers. When he realized they were officers, he quickly put it down and closed the door. Or maybe he closed the door and quickly put it down. The reason I bring this up is because we were polling the jurors, questioning the jurors to try to figure out who was going to make up our jury. And we asked the jurors to rate their local law enforcement, maybe on the questionnaire. A 1, I think they're terrible. A 5, I think they're incredible. And to try to expose bias.
Mm-hmm.
So in front of that jury, I got up and I said, and I represented the person accused of assaulting an officer, and I said, just so you know, I'm a 6. On a scale of 1 to 5, if you ask me to rate my local law enforcement, I'm not a 1, they're terrible. I'm not a 5, they're amazing. I'm a 6. That's how much I trust and admire. Yeah, so, but it doesn't mean I'm blind to the way the law works. And if the jury charge says what it says, even if I believe Dean was justified, I don't think I can vote to acquit based on the justification, because Atatiana Jefferson was not acting unlawfully. Unless she was, and that's a question of fact.
Which the jury will have to decide.
The jury will have to decide. And they may rely on Zion's testimony.
And they might, and that's where which is why Bob Gill
focused so much on
his original
statement.
testimony.
That's right. I agree with you.
That's where
But then a juror could say, okay, well, maybe Zion says he thinks he saw a badge, but how can we make his knowledge her knowledge?
And that also goes back to the half a second.
That's true. That even if she did,
she didn't have a chance to react, one way or the other. She doesn't have a chance
to defer, to show deference, to put down the weapon, to call out for help, to
say,
and now, hey, okay.
Yeah. And then, so I also thought this was interesting. Dale pointed out that had she been doing like this, like more like this, she would have had glass in her hands because she had glass in her face.
He called it the cone. He described maybe the
cone of glass. He said cone of glass, and I thought that was interesting. That was an interesting point. He was basically trying to say that based on
where
the trajectory of the bullet and her not having glass in her hands, that it was more likely that it was more like down.
Because he, well, wait a minute. Let me think about that. Because if the expert testified that the way that the glass exploded once the bullet passed or hit the glass, it caused injury to her.
I'm not clear on where in her
forehead.
Face. Yeah, but it was in her face. Yeah.
And well, so I don't know. I don't know if I can wrap my brain around that, because if her hands were down low and it's a cone, but I didn't hear the testimony, so it's unfair for me to really.
But
have
I just thought that was interesting. Like, it's just an interesting argument. I mean,
and both sides, the defense and the state, when the facts are in your favor, like a forensic fact like that, that is something you want to play upon, because you can say, well, the evidence doesn't lie. The evidence doesn't have the human condition or memory issues or bias, because forensic or physical evidence kind of speaks for itself. And so by pointing that out, he probably reached somebody on the jury.
We'll see. We'll see. So is Rebecca available?
Yeah, give her a call.
All right, I'll call her, and then we will take a break here soon. After we do that, let me call her. Okay, here we go. Let me get Lopez on the phone. And then Rebecca can tell us what she thought about everything.
Hello.
All right, I'm gonna put you on speaker, and then we've talked about what we think. We're gonna listen to what you think. All right, Rebecca, go ahead.
Well, I thought that both sides gave powerful arguments. I thought, though, that the prosecution did a really good job of tying it all up into a bow and handing it to the jury, saying, listen, he put himself there. He put himself in danger, so you can't claim self-defense if you put yourself there. And I think that I was wondering how they were going to raise the question about the green laser, because that was something that the defense promised, that they would show that the he saw that green laser. He felt that green laser was pointed at him, and they never gave any kind of evidence of that. And I thought that they raised some, good points of, did he really see that weapon? There's no way that he really could have seen it. So I thought that the prosecution had a very strong closing argument. Of course, and then that, you can only use self-defense if, obviously you feared for your life. So, I thought that was very powerful on the part of the prosecution. Mm-hmm. I thought the defense also, raised some questions that were powerful as well. So.
Well, what Erin Hendricks is here. We were talking about. She keyed in on something Ashley Diener said, which is that even if Dean believes, that he's, defending himself or someone else, if the jury concludes that Atatiana was not acting unlawful, then they must convict, regardless of what he thought. That was I thought that we both thought that was an interesting, or she thought, because then she's a lawyer, she picked up on it immediately.
Yeah, so absolutely. We were talking about that amongst ourselves in the media, that was, something that we hadn't heard. And honestly, that was a little surprising to me, that obviously they said, it was unlawful, that, they had to show that she was committing an unlawful act. Well, that's why then the defense tried to say, well, but he was in full uniform. He was in uniform, and it's unlawful to point a gun at a police officer. But did she know there was a police officer out there? That's the part that's going to be hard for the defense to overcome.
Yeah, she had about a half a second is what he gave her. So Rebecca, kind of what's the mood at the courthouse? Like, what's going on there? Can you just give us a description of, the tenor of things, and if anybody's talking out there right now?
No, it seems pretty calm right now. I think everybody is just sort of breathing a sigh of relief that all of this at this point is, like, all the witnesses and all the testimony is over, and now it's in the hands of the jury. And I think that there is some, relief. The judge did tell us that there's probably going to be a 30-minute lag time before they read the verdict. He's going to give us a little bit of time. I think they want to make sure that everything is in place, and that there's security all around the courthouse. I've seen, again, a lot of DPS troopers. I don't see any protesters, though. There have been no people out here with signs. I mean, typically the last couple weeks there have been people out here with signs that say "Justice for Atatiana Jefferson." I have not seen any of those people today, and I have not seen some of the people that I was expecting to see that typically come out for this. Either in Dallas or, in other cases where there's officer involved shootings. I at least have not seen them at the courthouse. So right now it just seems like everybody's just waiting.
Yeah. Do you know if the jury is actually deliberating right now, or if they're on a break?
I believe they're still on a break. I don't think that they've started deliberating, because I know that they were bringing in their lunch, and I know that they obviously have to elect a jury foreman. So I would just say that it was given to the jury at 11:14 is the time that we all wrote down in the media room.
Okay. All right, folks. We're gonna Erin and I are gonna go take a lunch break, because this could be a very long day, and so I tell you what we're gonna do. We'll come back in about I don't know, 45 minutes to an hour, and we'll chit chat for a while. If you guys want to put your questions in the chat, I'll get Ryan to kind of keep an eye on those, and he'll collect them up and send them to me, and we'll try to answer questions. We'll come back. Let's plan on 1 o'clock. So we'll see you guys at 1 o'clock. All right, folks, we're back from lunch. I'm Tanya Iser, investigative reporter here at Channel 8, and joined by Aaron Hendricks, who's our legal expert for the day. So we're just going to talk for a while because we're waiting on the jury. They're out deliberating. And so, you know, Aaron, is there any way to ever know how long a jury is going to deliberate?
Oh, no.
The tea leaves?
The tea leaves would say, so if you consider how many hours of testimony were there?
I don't know.
3 days of prosecution.
Well, I was like, more like 2.5.
So
really.
2.5. I mean, I say an hour per, so maybe 5 hours of deliberation.
If you had to ballpark it, is that typical? Did they usually sleep on it overnight in your experience?
I think it could cut either way. There's some people who'll say a jury who dines together convicts together, or there are these phrases, or a jury who sleeps on it will convict.
Is that really true?
No, it's baloney. There's no real way to know. It's interesting though, because of course this group, if they don't make a decision today, they'll be sequestered. So they will not be permitted to go home to their wives, husbands, children, parents, roommates, dogs.
They don't get phones, do they? Do they get any kind of like technological
so that's
thing?
interesting. I don't know whether they'll be able to communicate with their families, but certainly they're not. The jury instructions that the judge read indicated that during deliberations they're not to have any access to media or internet. So yeah, maybe not.
Does that give them a greater impetus to pick up the pace?
Think about it. If it's you and you mentioned your son and you're thinking to yourself, okay, I'm going to go stay at the La Quinta with 11 of my new best friends in separate rooms.
But it'd be peaceful.
Oh, well.
I do love my kid, but it would be peaceful for a night.
Someone else who I know might say the same thing. But I feel like it, I don't know, I would be pretty motivated to get the job done.
Right. I think most people would be.
Yeah. I was seated on a jury in Dallas County a few years ago. And granted, we reached our decision quickly, but you know, everybody in the room has a different motivator. Some people were in a hurry because they didn't want to miss work the next day.
Mm-hmm.
Some people wanted to get home to their families. Some people were in a hurry because they were mad that they were there.
Mm-hmm.
One guy was in a hurry because he was mad at the defendant and he wanted to convict him quick.
Right.
And then one lady said she was going to take all the time it needed to convince us otherwise. And anyway, but everybody has a different motivation. And yeah, how long they've been impaneled for? They started last. No, but they
went out at 11:15.
But they've been impaneled as a jury since last Monday, the 9th.
Yeah.
So they've already given 5 working days, but they didn't work on
Thursday and Friday. So Thursday and Friday, remember
they got a break. But this week they've missed Monday, Tuesday, and Wednesday of life.
Yeah.
To be there.
Yeah. So it's about 6 days of life right now.
So I think we should expect up to 6 hours of deliberations. I mean, I'm making that up, but that's
it's a ballpark. And then does that tend to be kind of how it works? Then?
Probably. I mean, like if you have a 2-day trial, they'll deliberate for 2 hours. A 3-day trial, 3 hours. But then again, even though the jury was qualified to sit on this case because they haven't had too much exposure, they still know that there's media exposure. They still know that there's a lot hanging in the balance. This probably feels, every single case is so important, but this probably feels very important. And there's so many stakeholders and there's so much presence in the courtroom, and these are Tarrant County residents. They're not all Fort Worth City residents.
Right.
So this isn't necessarily their police department, or the young woman who was killed in her city of Fort Worth. These aren't necessarily her neighbors, but these are all members of that community. So they probably feel the weight. So that could slow things down. That could they could go in there and take an initial vote and see that they're all on the same page, but they still might deliberate and not return a verdict for a couple of hours because they know how important it is to get it right. And
plus they got to even the act of going through that jury charge, just the act of like going through and answering the questions and doing all the things can take a while in and of itself.
How long did it take the judge to read us the jury charge? Do you remember, like 25 minutes?
20 minutes.
Yeah.
25, yeah.
And he's read those jury charges 1,000 times. He knows exactly what the words say and what they mean. There could be things in the instructions that, there could be foreign words, new concepts, things that they need to kind of discuss and deliberate. Now, he was pretty specific, not that they would do this, but he told the jury, it was very, very intense, that they have no right to question the instructions that have been given them. So if somebody wants to go back there and take issue with the instruction or have a concern about the charge, arguably, they don't even get to do that. They just have to get down to the meat of it. He specifically told them they cannot apply their own interpretations of the law. But they're all going to interpret the law, according to their own perspective. So you're right. Just getting through the instruction
can take time.
A task. I agree.
Hey, Ryan, did you have something you want to tell me?
Yeah, on the jury instructions, the murder versus manslaughter thing, like, what do you think that discussion is, and do we have any insight as to...
Okay, we can talk about that.
Yeah, just kind of the differences between and what they're going to be looking at there.
Okay, so Ryan wants us to talk about the differences between murder and manslaughter and kind of how that's going to work. So let's walk folks through murder and manslaughter and what's the difference between those two charges.
So
what
in
they'll be looking at.
in Texas, the judge explained the definitions, and it's pretty straightforward. Murder is a knowing or intentional killing, an unlawful knowing or intentional killing, unjustified. Intentional meaning it's your conscious objective or desire to reach the result or to cause the result of your action. Knowing is not much different. Whereas, murder in Texas is a first-degree felony, and it carries a higher range of punishment. And it's a 5-year minimum, 99-year or life maximum. But manslaughter is a little bit different. It's a second-degree felony, so it's a level lower. And the law that applies in manslaughter is it's a reckless killing, an unlawful reckless killing. And reckless, of course, means that you consciously disregard the risk that your conduct could cause a particular result. And actually, there's more to reckless. You consciously disregard that risk that you're aware of, and your disregard is a gross deviation from the standard of care for the ordinary prudent person, the OPP. So that's the difference. So manslaughter is really a reckless act.
Right.
And the judge defined all that. It got a little confusing. The judge also talks about if you intend to cause serious bodily injury or death and you commit an act clearly dangerous to human life intentionally or knowingly, that's another way to get to murder. But it's pretty much you want to, you mean to, versus you're reckless about your behavior and that there's a pretty big risk you're going to hurt somebody or kill somebody, and you do it anyway.
Right. And you and I were talking before we knew that for sure that manslaughter was going to be a lesser included, that you didn't really think manslaughter applied here. And I guess the question is, why not?
My perspective from listening to Dean's testimony was that he admitted under oath that he intended to shoot and he intended to kill. So he basically said it was his conscious desire or objective to intend the result of his behavior, which was to shoot his firearm at an individual, a human being, and cause the death of the other. I mean, these police officers are not trained to shoot to wound, if you think about it. They're trained to shoot to kill. And so he admitted
Or shoot
that.
to stop the threat.
Okay.
I mean,
eliminate the threat.
Yeah.
So they're not intending to shoot to distract the threat or throw the threat off. It's eliminate the threat. So, okay, so shoot to kill. And he said that. He said he didn't admit that he did it without justification, and he claimed self-defense. But my point is he admitted it was an intentional act. So I didn't necessarily expect for sure that the manslaughter would be included in the instruction, because that requires a different mindset. And
why do you think we got included?
Well, perhaps some of the testimony and evidence indicated that there was some recklessness in his behavior surrounding the shooting. Maybe there was some consciousness, some conscious disregard of the risk that some of his behavior surrounding the moment when he actually pulled the trigger. And maybe that all of that was a gross deviation from the standard of care that applied or that should have applied. So maybe that was the basis for the inclusion of manslaughter. We didn't get to watch the charging conference, which is when the litigants talk to the judge about what the instruction should look like, what should be included. Sometimes they like to argue about what order it should go in. For example, at the end, Judge Gallagher gave the jury their 3 options. First, not guilty. Second, guilty murder. Third, guilty manslaughter. So sometimes they want to argue about that, and maybe somebody wants not guilty to be the last option versus the first option. So these are all the things that the parties are going to argue about at the charging conference.
Is that ever done in open court?
I feel like it is done in open court. It's and it's some of it is going to be most of it is going to be on the record. Maybe some of it is done off the record and outside the presence.
Yeah, they didn't do any of that in the presence. They didn't do any of that
in the presence of the media.
Right. Well, yeah.
So maybe it was in the courtroom when no media was present? Is that possible? Or maybe they did it in chambers?
I think they probably did it in chambers, would be my guess. But it's based on, like, you know, when he wrapped up court yesterday, he said, you know, I'm done for the day and going to talk to the lawyers. So.
Sure. So that the conversation can always happen, but at some point, if there are objections or suggestions for the charge that the judge is going to grant or deny, that's got to be in the presence of the defendant, at least, because he has a right to be present for all the proceedings. So something was on the record at some point. Yeah.
People are asking if he's going to be, if he's convicted, if he'd be sentenced by a judge or a jury. At the beginning of the trial, he elected to be sentenced by a jury. Should it get to that point?
Right.
Why is it done that way? Why do they do that?
Texas is unique. We have this bifurcated process for the question of guilt and then the question of punishment. And I suppose it's just within the right of the defendant to make that decision. So are you saying why is it that way, or why would you choose jury over judge?
Why would you choose a jury versus a judge?
Well, I guess I'm going to think about it through the eyes of a defense attorney, because that's the kind of practitioner I am right now. And that is to say that maybe if there's a wide range of possibilities, and I think that I want maybe a wide range of opinions about all those possibilities so that there will be some real legitimate discourse about what the outcome should be. In other words, I want the jury, I want 12 persons, like 12 individual brains to all have to work with each other to fashion an outcome.
Negotiate it, yeah.
Yeah, because maybe that could work in my client's favor if I think this is a strong case for the state, but I've got a couple good arguments. I want to make sure that I can reach, of those 12 jurors, maybe 5 or 6 of them really want a maximum punishment, and then 5 or 6 not so much. I want them to do the work. Now,
meet in the middle.
Yeah, the jury charge, and if we get there, we will hear it, talks about that you're not to use whim or draw lots or cast lots, or these words that no one uses, by the way. But the judge tells you can't just do this whimsically. You actually have to negotiate, and you can't compromise. But of course you can.
I mean, come on, we live in the real world. People compromise.
So, in other words, I think that's not like everybody drop it in a hat and somebody pick it out and that's the answer. No, they all have to fight and argue and collaborate. But whereas if maybe you have a case and you want the judge to fashion the punishment,
right?
Well, maybe given the facts of the case, the nature of the allegation, the nature of the defendant, what kind of crime you're dealing with, who the judge is, who are the parties, the temperature of the courtroom, the community, all those things may make a difference on whether you want to have like a single fact finder determine punishment versus having 12 people all work together to figure out what the right outcome is for sentencing.
Somebody's asking, if he's found guilty, will he be taken into custody ASAP? My recollection is if you're found guilty, you get taken into custody.
I would predict that he would be jailed.
Yeah, that's what they did in the Geiger case. I remember that actually.
Yeah.
Because she was out on bond until they found her guilty.
Right.
You know, and that's one thing I want to talk about because, I mean, I recognize there are differences in the Geiger case. For those of you that, I'm sure most of you are familiar with the Geiger case, Amber Geiger was a Dallas police officer. She was in uniform. She'd gotten off work after a long work day, and she went back to her apartment in Deep Ellum, or what she thought was her apartment, and she got off on the wrong floor. I believe she lived a floor above Botham Jean, but the floors and the doors and everything all looked very, very much the same. And so she went to what she thought was her apartment, and she and because of a malfunction with the door was not secured, and she encountered Botham Jean in his apartment. She thought it was her apartment, and she shot and killed him. And he was eating a bowl of ice cream. And
unarmed,
and the jury in that case, I felt like really took into account that she made an affirmative decision to go on into that apartment, and that he ultimately was in his apartment, and I think also what medical care was rendered or not rendered. I mean, she did try to do something, but I think there was a feeling that not enough was done. And anyway, she got convicted of murder, and her attorneys tried to argue mistake of fact.
That she was mistaken as to the fact that she was not in her own apartment.
But that she was really reasonably in fear for her life. And so what's your thoughts on just a comparison between these two cases?
Well, I guess the main difference that sticks out to me is when we're thinking about Aaron Dean responding to this police call. He's in uniform, acting as in his capacity as a police officer, and he's purports to have been making decisions based on his role as an officer, which is the biggest difference right off the bat. Because even though Geiger was a police officer, she was not on shift. She wasn't responding to a call. She wasn't actively engaging in the discharge of her duties as law enforcement. That's the big first difference I see. I mean, there are a few. There's nothing about this particular case, Aaron Dean's case, that involves necessarily an assertion that there was a mistake, or that he was mistaken as to an established fact, or that affected his behavior, his decision making. So I think that's also super different.
Yeah, I mean, the big similarities is you have two people
in their
own place, just minding their own business, when they have these encounters with law enforcement.
Somebody could argue, or somebody might say, well, the difference, another difference here is that this young woman was in her own home, but she was armed, but
lawfully,
right? As would have the other gentleman had he been armed in his apartment when he was killed, but he wasn't. I mean, I guess that might be another difference, but it may not make a huge difference on the law, because she was probably within her legal right to be armed. The big question is going to be is how she perceived Dean's presence on the outside of her house, if at all.
Well, we don't know.
We don't know. But the jury's going to try to answer that question, because they're going to have to answer that question to determine whether they think she was lawfully or unlawfully either possessing a gun or pointing a gun or whatever it was. I don't think there was anything unlawful about her being in possession of a gun inside her house.
No,
Nothing.
No. I mean, I don't, and they said, it's pretty much proven with the analysis of the body cam that from the moment he starts saying, show your hands, And the moment the shot's fired, it's about a half a second. So there's
which really we kind of agreed earlier that it may have been almost at the exact same moment, given the time that it might have taken Dean
to actually pull the hammer back and fire. Yeah, I mean it's all kind of happening simultaneously.
I mean, if you listen to the audio, if you try to take out the video and you hear his voice and then you hear the shot, there's the tiniest. You can discern between the two. But it's so close.
Hey guys, what questions do y'all have out there? Because we want to answer them, and so I want to make sure that we're not missing any. I'm trying to watch the comments here and also chat with Aaron. Aaron, let's I don't in case folks missed the closing arguments, or if they just want to hear us talk about it again, let's kind of walk back through closing arguments and what we thought of those. So Ashley Diener kicked off the closing arguments, and let's talk to us about what she had to say.
I remember that she opened really strong. You probably remember she looked at the jury and very solemnly said, if you can't feel safe in your own home, where can you feel safe? She talked about how sacred your home is. She probably wisely called upon everyone's memory of the recent Thanksgiving week, and imagine you're in your own home, you're in your kitchen, you're in your living room with your loved ones. I tuned out for a split second. I think she made reference to imagine your living room right now. Maybe you have a Christmas tree up, or maybe some other symbol of a holiday. And so she started off talking about that the safety and sanctity of our homes as we know it has been compromised because of Aaron Dean's preconceived notions, whether it was about the neighborhood or whatever it was. And
that's something we can all connect with.
Right. So I thought that was pretty impactful. I didn't know which way she was going to go. I didn't know if her whole open to the close was just going to be about how this police officer violated that trust that we have in our community and so forth and so on. But she pretty quickly went right to him. We don't just take his word for it. Just because he gets up there and he says, I did that, but I did that with justification. Just because he says so doesn't mean we have to believe him. And she was saying artfully, y'all don't have to believe what he said just because he said it. And so she focused on the piece of the jury charge where the jurors are instructed that if they believe that Aaron Dean, the police officer at the time, shot and killed Miss Jefferson, but he did it in defense of himself or of his partner, that would be a justification, but that he wouldn't be justified in using deadly force against Miss Jefferson if Miss Jefferson was using lawful deadly force against him. So in other words, she's inside of her own house. She has a gun pointing at her window because she hears maybe what is
well, we don't know if she's really pointing at the window. I mean,
okay, she has a gun in her hand.
Right.
There is a gun and she's in her home, and there is nothing unlawful about any of that we know.
Yeah, she's not a felon. She has every
reason to have. Yeah. So so Ashley Diener's open to the close honed in on that aspect of the instruction, that the only way he's justified is if his use of deadly force was against her unlawful use of deadly force. And that's a pretty critical point, because even if there are folks on that jury who want to believe that he was justified in his actions, they may not be allowed to acquit him on that reading of the law.
If they get to that point, or they picked up on that, it'll be interesting.
Right. Or if that's how they interpret the instruction. I mean, look, the judge told them you can't make up your own laws and you can't make up your own facts, and you have to go by the evidence in this charge. But if the jurors want to interpret the law that way, they can. They're the exclusive jury. They're exclusive judges of the facts proven and the weight to be given the testimony, and so.
So I'm gonna. We can keep going through some of what was said, but I want to also answer some questions here. So Paige Moody wants to know if he's found guilty, when would sentencing begin? Let's talk about kind of what that process is.
I get the feeling that typically sentencing begins right after the verdict. Sometimes logistically, maybe it might, if a verdict comes in at 11 a.m., maybe they would break for the balance of the day and then return the next morning to convene on sentencing to put the jury back in the box to hear the evidence for purposes of punishment.
So it depends on if they have punishment witnesses there and ready.
At the ready, that's true. Or if they, it all just sort of depends. Also depends on the judge. The judge he's in charge of the court. And if he says, okay, the jury, we've received your verdict. Now we turn to the issue of sentencing. Is the state ready? I mean, he could look right at them and just say, let's go. And but
he seems like the kind of judge who might do it.
He's not. I really like him. I think he's really great to be around. He seems very fair, but he is no nonsense. He also, I think he appreciates the time and the sacrifice that these 14 people, are having to make to be a part of this trial. They probably did
Well, the alternates would have been released, right?
After the verdict. That's a good point. But nevertheless, he is, I think, cognizant of that all along the way because he wants to keep things moving. And but surely the parties are going to have these conversations without us knowing.
Oh, yeah.
Hey, judge, if there's a verdict and it's guilty, we want you to know that we're ready to proceed on punishment right away. Or, hey, judge, our first witness is coming in from out of town. We won't be able to start until tomorrow morning.
Okay, so Melissa Chalupa wants to know, by law, is he as an officer required to allow her time to retreat, lower, or drop the weapon?
Melissa's asking whether the officer has to give her
time to
civilian an opportunity to follow his commands.
Right.
Well, by law, I don't know, but doesn't that make sense that he should? At the same time, should he have to, if he's looking at a gun pointed right at his person, does he have to wait? He doesn't have a duty to retreat.
No.
So that's a great question. What do you think?
These are interesting questions because we get back into the question of, is her conduct unlawful? Because she doesn't, from what we can tell, we don't know that she even knew there was an officer outside her window.
Right. It seems like from the evidence it was pretty obvious she knew something was outside her window because of what the child said, that she went to arm herself. But if she doesn't know that that's a police officer, she's allowed to use deadly force against the threat of deadly force if that's what she thinks is going on outside her window. What if he had his weapon drawn, he had his flashlight looking in. In the state of Texas, you can use deadly force to prevent the others' unlawful use of deadly force. You could also use deadly force to prevent certain crimes from happening, like, for example,
a burglary,
aggravated sexual assault, aggravated robbery, home invasion, all those things. So if in her mind, her subjective belief, reasonable under the circumstances, 2:30 in the morning, dark of night, she thinks there's somebody outside her window and maybe he's fixing to...
Right.
She could have shot him.
That's the complicated questions of all this, is that it's tough, but it's.
But really, this person is asking if he had some sort of affirmative duty to wait and give her a chance to respond to his command. And I don't know.
Why issue a command? Like, if you're not going to
not going to allow performance.
I mean, what's the point of a command? Like, if you're not going to let the person, because you know what I'm saying? Like, what's the point of a command? Like, because she's in her house, and he has not announced himself.
Imagine this is a different scenario, and
he's placed himself right in front of her window.
Right. But I'm saying, like, imagine you have police officers and they encounter a guy on the street, and the guy on the street has a knife in his hand, and the officers pull their weapons and point them at him and say, "Hey, drop your weapon." They don't shoot him as they say it. They give him a chance to comply, right?
He doesn't have much time,
and if he drops his weapon, they're not going to shoot him because he's no longer a threat of deadly force against them, right?
Right.
I mean, it's different when we're talking about guns versus knives. They're all deadly weapons. I don't know what their standard operating procedure is, but it stands to reason that if it's a command that's issued, then there has to be the opportunity to comply.
Somebody's asking about the bullet trajectory, and I don't feel like I know enough to try to parse that one. Let's see. Oh, somebody wants to know if there's been any questions asked by the jury. Nope, no questions. Let me ask you this, though, while we're on the subject of jury questions. How much can we read into the questions from a jury?
Okay, well, it depends on the question. But if a question does come out, by the way, for your viewer who wanted to know if there's been one, Everybody would know because a question can't come to the court without all of the parties being aware of it. And if there is a question, it involves being on the record, it involves the court reporter, it involves the judge. The defendant has the right to be present as well. And so we would know if a question came. And you know that a question has to come in written form. It has to be sent out by the jury through the deputy, the bailiff, the sheriff who's in the courtroom to the judge. There's a whole process. And I think you can read into jury questions, but it just depends on what it is.
Well, somebody asked, so she would have been justified if she had shot first. She had no duty to announce it as her home. If she thought it was a burglar.
Right? So at night in Texas, we've talked about castle doctrine and that you have the right to use deadly force in your home in Texas, in your home or on the curtilage, which is like the immediate outside. So your front porch, out the window, whatever it may be. So I think that person's comment was a comment, not a question, right?
Yeah.
Yeah.
Let's see, I'm kind of looking back through here. Some of these, what happens is folks, these comments start rolling pretty fast and then it's hard for me to
find them.
Says, somebody asked, can I point a gun at an officer if they come into my backyard? The thing is you have no, but you have to know that they're an officer to know that it's unlawful.
If you know it's an officer and they come into your backyard, and if you don't like it that they're there, you can't display deadly force at a uniformed police officer. No, that is an offense. Okay, but to be fair, Tanya, if a police officer comes in your backyard and he's in uniform and he has a knife and he says he's gonna hurt you if you don't take off your clothes and have sex with him, you can shoot him.
Well, yes.
Okay,
that would be a bad thing. But yeah, I mean,
I'm just saying, like, I don't think
right.
That's
right. Yeah.
But I mean, if an officer comes into your backyard, let's say they have a warrant, no, you don't have a right to shoot to point a gun at them.
Right.
Or even if they don't, yeah.
We got about 90 seconds of Gill's closing and then the end of Dale Smith's closing. Do you want to play those out?
Yeah. Can we listen to it on our ear so that we know what you're playing?
Yeah. Let me just set that up.
So Ryan, our digital producer, is pulled about 90 seconds of Dale Smith's closing and about 90 seconds of Bob Gill to play for you guys. And so
remember, just on the Gill clip, he's talking about how it was. He says it's unlawful to shoot, to point a weapon at a police officer. Now that's the whole contention, like at their thing. But I'll just play it out, and then we'll play Smith's after that.
All right, so we'll listen to these.
Because it is always against the law to point a handgun at a uniformed police officer. And that's what happened here. It's tragic, but it's not an offense under the laws of the state of Texas. The jury charge contains verdict forms at the end. The proper jury verdict form for your use is the top one, which says, we, the jury, find the defendant, Aaron York Dean, not guilty. He's not guilty because he validly exercised his right of self-defense on that occasion. And he validly and reasonably exercised his right to defend a third person, that being Carol Darch, who he had every reason to believe, based upon training and experience, was going to be right behind him where her training told her she needed to be. And she was. And she was in the line of fire, just the same as Aaron Dean was. So, nothing that we do here this week is ever going to bring Miss Jefferson back, unfortunately. Nothing can change that. But by the same token, the tragedy should not be compounded by finding guilty a man who was relying on his rights as a police officer and his rights under the laws of the state of Texas. We would ask you to find Mr. Dean not guilty of these charges.
Okay, so we were just listening to Bob Gill, who is one of Aaron Dean's attorneys. Let's talk a little bit about what he had to say, and then we'll play Dale Smith. You know, just kind of talk about, the point he's making is basically that Aaron Dean what he's arguing is that he had a right to protect himself and his partner.
Yeah, he did start, that clip that you played started with, "It is always against the law to point a gun at a police officer."
And it is.
Sure. If you know it's a police officer.
Right.
Yeah.
And there's no evidence she knew it was a police officer.
Well, I just, for the sake of argument, I would say that her nephew was in the room, and her nephew did say in a forensic interview that he saw a badge.
Yeah, he thought what he saw was a badge, but we don't.
Yeah, you know, but at that point, the child knew that it was the police because they had come into his home, and he put two and two together. But someone could argue that that is evidence that it was obvious, and if that's the case, then no, you can't point a gun at a police officer. There's still the question of whether she actually did point the gun, or whether she was armed. I think there's a big difference there.
Right.
You know what he said at the end just now, or before the end, was, "Nothing we do here in this courtroom will bring her back." I suppose that's a preemptive measure for when Dale Smith gets up and makes emotional arguments about the loss of life. So he suggested that is a tragedy that she is dead, and that it will only compound the tragedy if he's convicted. That may or may not appeal to the jury. That could appeal to a couple of the jurors. A couple of the jurors might be like...
And they just need one.
Yeah.
I mean, that's what it comes down to. The prosecution needs 12.
Yeah, because the verdict for guilty has to be unanimous. And if they can't reach a unanimous verdict, then it could be a hung jury. And arguably an acquittal also has to be unanimous.
That also has to be unanimous. But I mean, one in terms of, you know, if you had 11 people that wanted to convict, and you had one who said one holdout, that's all they need. But obviously,
and when you say that's all they need, you mean all the defense needs is
to prevent
one
a conviction.
To prevent a conviction,
right? That's what I mean.
So right now, they can always come back and try that again later. Just because you get a hung jury and there's a mistrial does not mean that the state cannot re-pursue the criminal charges.
Right.
And they definitely
would suspect that if we were to end up with a hung jury in this case, that they would retry. I would be
1,000,000%, I think.
And then so I'm kind of looking at these questions, trying to sorry guys, y'all are putting questions in chat, and I'm trying to grab them so we can try to answer them when we get to that point. See how fast these comments are rolling.
Yeah, and I see the second one. At WFAA, can you go in the backyard when you think a felony is in progress? Do you mean, can I go in my backyard, or do you mean, can an officer go in the backyard? Because I want to answer that both ways. Because it makes.
I think that means an officer. That's the way I took it.
Well, so law enforcement officers can make warrantless arrests when there is a felony in progress. They can also make a warrantless arrest on domestic violence, misdemeanor, as well. But can you go in a backyard when you think a felony in progress? Ooh. So first of all, the officer would have to have reasonable suspicion that a crime is being committed, and then to make a warrantless arrest, they'd have to have probable cause. But I would need more facts. So if there's a felony in progress and somebody calls and says, I see a man and this is controversial, but here I go. He's beating his dog with a baseball bat. That's felony animal cruelty. I see it, it's happening right now. She calls 911, and officers respond to that, and there is the caller, the observation, and then maybe there are noises or there are other things that corroborate that, I feel like the officers could absolutely go in there.
Right.
Yeah.
And in this particular case, what we had was they looked in, they saw what they believed was a ransacked house, and that gets back into like the policy, which
procedure.
was you back off, you call for cover, that kind of thing. So I don't know. I mean, that doesn't mean it's unlawful to go in the backyard.
On the other hand, yeah, and I agree with you, but on the other hand, I remember that anecdote that Edith, our legal assistant, shared with me about a neighbor in Dallas who had called the police to say, hey, there's somebody in my neighbor's backyard who shouldn't be there. And the police said to Edith, well, Edith, we can't go into your neighbor's backyard without their permission. Now that's a little bit different because perhaps that scenario didn't involve a violent felony in progress.
Right. I mean, that would probably depend. I mean, that's the thing is like,
it depends
yeah.
So yes, I mean, an officer is not going to allow a felony for the crime to be completed on his watch. He's going to go and he or she. But that being said, there was nothing about the call for service in this case that indicated a felony in progress.
Right. Just
right?
The ransacked house is all we, or the appearance of a house.
And it very well could have been and was, according to his testimony, Dean's subjective belief that that's what he had. What have we got here? Well, we've got a burglary, maybe in progress, which is a felony.
Right.
But then the protocol might have called for a different response, might have called for a different approach. When the female officer, when his partner testified, did you hear her testimony?
Yeah, I did.
So did she, and we talked about this earlier, but did they confer on next steps?
It was all very brief. This is all happening,
like
very
that,
quickly.
yeah.
There's not like, they're not
Time
really
to
like,
reflect.
They're not like calling a supervisor and saying, hey, we've got this call. They're not, walking across and talking to
the witness.
To the witness. And now again, that doesn't mean his conduct is criminal and the ultimate act to shoot her. It just means that, there
some decisions.
Yeah, some decision
made.
making. All right, Ryan, you want to play the Dale Smith clip real quick? So Prosecutor Dale Smith, who was the last person to speak to the jury before they went out to deliberations, Ryan has picked a clip from him to play, so let's take a listen.
And again, what is unlawful about protecting your nephew and protecting your home? Even the defense's own witnesses all agreed what she did was not unreasonable. And again, you'll never see it in the court's charge. You can look through every page. It's not from what the defendant sees. It's from what a reasonable, prudent person sees in the same circumstances. And I tell you right now, no reasonable and prudent Fort Worth officer would have gone hard charging, gung-ho, past those two doors, into that backyard, creating a situation of danger for not only himself, his partner, and anyone in that home. Because he's the one that made the decisions on October 12, 2019. He's the one that ended Atatiana Jefferson's life, and he's the reason that we are here. This is a matter of accountability. Tragedy, an accident, that's spilling your milk at breakfast. This is murder. Someone lost her life. Atatiana is no longer here through no fault of her own. And now you're going to decide if someone's going to be held accountable or not. And you're going to have to look deep inside and look at this evidence. And he never saw that gun. He didn't know what he saw. He was hard charging. He was gung-ho. He finally got some action.
Well, Ryan picked well. He picked probably what was my favorite part of what Dale Smith had to say, which is that spilling your milk. Just that kind of gives me chills. But it was a powerful kind of moment. And so I don't know. It'd be interesting to know. Like, I'll be fascinated when we do get a decision from the jury if we find out like what plays a role in whatever way they go on this.
In that clip, did we hear him say her only crime was love and protection?
Oh, that wasn't in that one, but
so He said that in his closing argument
that was a good
right
part, too.
before he got to this part about nothing that she did was unlawful. And that was also pretty powerful. And then Ryan ended that clip with, oh, go ahead.
Yeah, he says that. Hold on, I'm looking back at my notes now. Hey, Ryan, he says the thing about her only crime was love and protection of her nephew. He says that right before he puts those photos in front of the jury.
Yeah, I'll go back and see if I can.
If you want to pick a couple more clips, and I want to make sure we pick from both sides. I don't want to just play clips from one side or the other. I want to make sure we're being fair. Yeah, but that's some powerful stuff. In your estimation, what do you think? Whose closings is going to carry more weight with the jury? Or is there any way to know?
There's no way to know. It does seem like Dale Smith was trying to paint Aaron Dean as a hard charger. Mm-hmm. He called him gung-ho. He used those two phrases a number of times, but not too many. And I feel like he was trying to characterize him. And then it all made sense when at the very end of his closing, or at the very end of that clip, the prosecutor, Mr. Smith, said he finally got some action, which I think played back to Ashley Diener's open to the close for the prosecution when she talked about how power can corrupt. Mm-hmm. I feel like she maybe laid the groundwork for Smith to come back at the end. And
you think would they have had that all written out? I mean,
oh sure.
See,
I mean, not written out, but they would have had it conceived of. Yeah.
So, like, whenever you write your closing argument, like, how do you? Because I've obviously never had to do one. I thought about going to law school back in the day, but I never got around to it. How does that work? Like, do you type it out? Do you just have a? Is it all extemporaneous? Like, do you practice it? What do you do?
Well, all of that. I mean, you type it out, you write it out, you make your notes, you go back through your notes from trial. I do think you collaborate with your partner. And I mean, if Ashley Diener and Dale Smith didn't speak to each other and they just happened to compliment one another the way they did, that would just be magical. But I'm nearly certain they at least talked about, okay, this is what I'm going to take care of, this is what you should address. Sometimes, if you split the closing. If you're just on your own and you're doing the whole closing argument and you're not collaborating with a co-counsel, then you're on your own. And yeah, you do. You got to figure out what your high points are. As the defense, you have to do a little bit of predicting and even the prosecution has to predict what the defense might say. You do want to try to take a little bit of wind out of the sails of your adversary. And I think, but the truth is, Ashley Diener's open to the close was equally passionate, as was Dale Smith's. But I think she laid the groundwork with power can corrupt, and then he comes back at the end and says that this hard charger, this gung-ho officer finally got some action. And I mean, that's probably what they truly, genuinely believe, but that was also a little bit dramatic. And that, because Aaron Dean is in the courtroom and he's pretty mild. He has a mild presence. He's not really reactive or bombastic, and when he testified he was pretty straight. There was the one moment when he maybe had a moment of, I guess it was humor or defeat, when he said,
frustration.
Maybe I should have just stayed home that night. But other than that, it was just straight.
And right, and he's an engineer by background, and so he went. He's raised in Arlington, majored in physics, minored in, I want to say, mechanical engineering, and he was a refrigeration engineer or something, like for a refrigeration company. And he's 38. He was homeschooled, which is kind of interesting. And I've known people that have been homeschooled. That can be done very differently. I know people that, I have friends of mine that I grew up with, a family I knew that they were all homeschooled, and they went out of their way to like socialize their kids and make sure they were around. So there can be some kids that are homeschooled that aren't around a lot of other kids, and there can be others where there's a lot of socialization. So I don't know. I mean, he
well, I mean, and he came across maybe as a guy
like an engineer.
Yeah, because he was pretty straight and pretty clinical, And the reason I mention that right now is because Diener and Smith very much tried to make him seem like he was power hungry and trigger happy, and that they were trying to paint a picture of him on that night versus maybe him for the past 5 days in the courtroom. And I imagine they probably reached some people on the jury, and then some folks might have been turned off by it. They might have thought,
I mean, I don't know that I buy power hungry. What I see is a young rookie officer who was intent upon, proving himself and, going out there and, rookie. That's why I think, and I've said this a number of times on this live stream, that I think that that's why it's so important for rookie officers to be paired up with more veteran officers, just because I think the longer you do that job, and I know this from officers I've spoken to, you get some seasoning, slow it down. There's rarely,
a lot of wisdom that comes with experience.
There's a lot of wisdom, and there's rarely any harm in just slowing it down. Just saying, let's call a supervisor. Let's go talk to Mr. Smith. Does Mr. Smith have Atatiana's phone number? Because we
could call over there and see if we get a call. Yeah, or maybe he knows the occupant of the home. They could figure out who that person is.
There's a lot of things, and that's why the question of whether or not his act is ultimately going to be considered criminal is one matter, but there is this other just bigger question of how police departments are training officers and preparing them to show kind of just. Some of it's just, I've said this before, common sense. Let's take some other steps before we go in a dark backyard, right? And place ourselves in what the defense called a fatal funnel, right? So I think that's all really important. So, let me while we're just kind of chatting here, what do you see as the strongest point? From the defense side, I mean, what is the strongest points? The things that you heard that you just think are the most powerful.
Fatal force meets fatal force. I feel like the strongest thing the defense has going for them is that, of course, an officer is going to respond to a gun pointed at him as a threat of deadly force, and of course he has to act to protect his life and the life of his partner. Of course. So I think the strongest argument they have is that,
and that may in fact be the only argument. Really? I mean, that's like
that is literally the only argument. Yeah, in my opinion, in my assessment.
So we got a jury note.
Jury note.
They
All
asked
right.
for writing pads, something to write on, and they asked for some evidence. We don't know what the evidence is.
They asked for writing pads and
They
evidence.
asked for certain evidence.
You sure you don't want to come over and talk to folks?
No, it's good.
Come on, Ryan.
You're doing great.
Writing pads
and they asked for some evidence. We don't know what evidence they asked for, but they asked the judge for some specific evidence.
Did they not read the note in the courtroom?
I don't know.
Did they leave us out of this?
I don't know. And the judge said that they're going to let them. He's going to let them deliberate as long as they want today. If they want to stay until midnight.
Midnight.
So however long they want to go, we may be.
Oh no.
Before sequestering them.
Before sequestering.
Yeah. So.
Well, I'm not going to try to convince Aaron to stay like crazy late because.
We've already gone an hour.
I know. I mean, her and I are apparently we can chit chat. We're probably going to take a break here pretty soon, just because you kind of like. You and I are good. I think we can gab.
I could probably talk all day long. Yeah, no, it's an issue. But this is a really interesting case, to be honest.
It is an interesting case.
Yeah, and the note is pretty interesting. So, remember how you mentioned that the judge took up their notes from trial?
So why would they need a note? Because they're
writing. So now maybe they want to tally a vote. Maybe they want to draw some pictures, and I don't mean that silly. I mean like maybe they're trying to see what it looks like. Maybe they want to diagram something. Maybe they want to list out their points of contention. I mean, they want to work. They're asking for pen and paper. They want to work. Of course, I'm wondering how did they get that note out?
And then you want to know, like, yeah. Well,
I'm surprised we didn't get to hear the note.
I wanted to hear the note. I'm like, because I wanted to hear exactly what was said, and
they may have asked for evidence by the exhibit number though, and then maybe we wouldn't know what it was. We would have been so disappointed. Mm-hmm. I bet your boots on the ground out there knows what they asked for.
Well, we should call Lopez because
we should find out
because Rebecca.
Because the jury's allowed to. They're allowed to ask for any of the evidence that was admitted in the courtroom to be sent back to the jury room for them to review.
All right, let's call Lopez. Let's see if she'll answer. I do not know. Let's see if she'll answer. See, my recollection in the Dallas County cases I've covered where we've done this is they read the notes in open court, but
they might just mark the note and add it to the record.
Yeah, I mean, you know, I honestly have not really covered a lot of cases in Tarrant County. This is actually the first big case I've dealt with out of Tarrant. Most of them have been out of
Dallas.
Answering. Oh, somebody's saying, well, maybe they asked for the body cam footage. I mean, I could see that. I mean, the body cam footage is pretty important. But I don't know. We don't know if that's what they asked for.
No, maybe they asked for the interview of the young man, the boy, the only eyewitness. Other than
I mean, if I was going to think about things they could ask for, I think the body cam footage is important. I think the forensics interview is important. I even thought what Dale Smith brought up about the trajectory of
they might ask for photographs. That's true.
That's all interesting. I mean, all that kind of stuff's interesting.
Yeah, what they can't do is they can't ask for a transcript of testimony unless they have a specific dispute as to like a particular
point. Why can't
point.
They ask for a transcript of testimony?
Because it would be so cumbersome for the court reporter to produce the transcripts. That's what I think. But if there is a specific dispute between or amongst the jurors as to a point in the testimony, they can isolate that point, and then the court reporter will have to go back and find that point, and then she'll have to produce a transcript of maybe that snippet of testimony, and then that will be marked and taken back for the jury to review, but only if they can articulate the disagreement about the testimony.
So somebody asking, how often do jurors deal with conflicting testimony?
Say that again?
How often do jurors deal with conflicting testimony?
Well, I think that
I guess that's often, I would think.
Well, sure. I mean, they probably are going to argue about who said what and when. And that is to the point about a note for a transcript. If there's one specific nugget of testimony that they have direct conflict over, they can request a transcript as to that dispute.
Right.
But they have to be in dispute, and they have to articulate it, and there has to be some way to guide the court reporter, the stenographer, into finding his or her transcription of that exact testimony in order for them to get it to actually look at it.
Okay. All right, folks, we're going to take a 30-minute break so we can just kind of collect our thoughts. Ryan promises me that he's going to monitor the comments and keep an eye on questions. He's got his thumbs up over there that he's going to do it for me. And then we will come back at 2:30. And then also, hopefully we can raise Rebecca on the phone and find out maybe a little bit more about if she happened to be in the courtroom or has any more intel on that question. All right, we'll be back at 2:30. All right, guys, we're back from taking a break. I've got Rebecca Lopez on the line, our senior crime and criminal justice reporter, or police and criminal justice. Okay, I'm getting tired, if you can tell. So, Rebecca, just kind of talk to us about what's going on at the courthouse. And did you happen to hear that question? Did they read it in court? We'd just like to hear a little bit more about that.
No, and I wish we were able to hear the questions, but the judge has locked the courtroom up for security reasons. Typically, we would be in there in the courtroom so we could hear the questions that the jury sends out, but he sent out one of the former reporters that used to work actually with WFA, and he was in the courtroom, and the judge sent him out to tell us that the jurors had a question and they wanted some sticky notepads to write some notes on. But the judge didn't say exactly what the jury wanted other than they asked for some evidence.
So,
and I don't know what happened if he sent back whatever evidence it was that they wanted, but they didn't specify.
That's interesting. I wish we knew what it was. I mean, you know, it would help with the reading of the tea leaves.
We asked for a copy of that, but the judge said of the question. But at this point, we were just told, like he just said, it was just a sort of a generic. They asked for evidence, and that's all we were going to get from the court. And then they did have lunch. Like they're actually having lunch. Now they're probably finishing up at this point, but they did take their hour-long lunch break. And then also the judge told the jury, look, we're on your time. If you want to deliberate until midnight, we can go till midnight. We go as long as you want to go today, because if they don't reach a verdict, he is going to sequester them. So there is, I guess, a little bit of incentive for them to keep, deliberating, but they also obviously don't want to rush this very important verdict.
Right. There's a lot of people hanging around there at the courthouse?
No, I mean, there were some family and some community leaders, but most of them have kind of went to lunch because we're going to get a little bit of a warning of when they know the verdict. So, like, we're going to have I think at least a 30-minute warning after they've reached the verdict for everybody to get in place. As you know, Tanya, they have to call back the lawyers, call back the family, anybody that, has left the courthouse for whatever reason. The judge wants to give them time to, get back, which is typical. And then also, there is security here depending on which way the verdict goes. They want to make sure that there's plenty of security here.
Is there a lot of visible security, or how would you describe it?
Well, there was this morning. You could definitely see there were a lot of DPS troopers, and then they sort of went back to the back where the judge and the lawyers were. And then you do see them, a couple of them here and there in the hallway, and then perhaps in other areas of the courthouse. And then there were bicycle officers outside the perimeter of the courthouse this morning. And, as you know, and I don't know if they have the same strategy here in Fort Worth as they do in Dallas, but typically, Dallas will have all of its, or the police departments will have all of their people ready to go, their crime response response teams just in case there is any kind of unrest if this were to be a not guilty verdict. And so we won't see them, though. They don't like to show all of that. They don't want to look like they're a military force and, intimidating. So typically, at least in some of the North Texas places that I've covered protests, you typically will not see all the officers, even though they're on standby somewhere.
Okay. Well, we're just going to kind of see how it shakes out. That feels like it's just going to be a long day of waiting. And then maybe a night of waiting, and then we'll see in the morning.
Yeah, they have, they obviously, again, the judge gave them the opportunity to keep deliberating. They have a lot of things that they have to, consider. And you and I were talking about some of the evidence, and especially some of the closing arguments, which were pretty powerful on the part of the prosecutors and the defense. And I would not want to be in their shoes, because I think that this is a very difficult decision, because at the end of the day, you have to decide, did Aaron Dean act intentionally or recklessly, whether he committed murder or manslaughter, or whether he was acting in self-defense because he really feared for his life. And it's just going to come down to, I believe, do you think that he saw that weapon? And if he saw the weapon, then, or
right,
was she committing an unlawful act?
Right, which was the point that...
Again, did she know that he was a uniformed police officer when she pointed that weapon? That's the other thing that they've got to answer. And so there's just a lot here for the jury to go through.
Did they actually ask for sticky notes or for notepads? Or do we know exactly
No, they asked for sticky notes. They asked specifically for sticky notes, not notepads. And they had been given notepads, obviously, at the beginning, and they were able to write notes. And then yesterday the judge told them, you can review your notes as long as you want. You can stay here today and review those, because, tomorrow it's going to be harder. You're going to be moving a lot more quickly, and you've got a lot to consider. So if you want to review your notes, and I will tell you, I've been in there a couple of times. Other reporters have been in there a couple of times. Others that I've talked to, they say that this jury has been taking down a lot of notes. And I will tell you, they were diligently writing notes when the defense was questioning Aaron Dean. They took a lot of notes, not necessarily the defense, but when the prosecutors were cross-examining, that's when you really saw them taking a lot of notes. I don't know if it means anything. I've given up trying to read the tea leaves when it comes to juries and what their reactions are, what their demeanor is, because, typically I think it's going to go one way and then it might go the other. So.
Yeah, I am always wrong about juries, so I definitely have given up reading the tea leaves.
I will say this, Tanya, that there are there's national press here today, which they've not really been here, but there definitely is a lot more media. I mean, typically it was just, the Star Telegram, the 4 Star Telegram, the Dallas Morning News, Carol D Radio, and then the rest of us, the rest of the media, TV media, but you didn't see national media. Now you see a couple of national crews. I know ABC Network's here, Good Morning America has a couple of producers here, and so there is obviously that some national interest
so
in
the
this
Johnny-come-latelys.
Yeah, well, and I think that part of, I think, why there might not have been, I don't know, maybe it's because of the gag order, and you didn't have access to as much as we did in some of the others. But I mean, I think
we had a gag order in Geiger.
Yeah, well, they did. And so I don't know. I mean, it just seems like there was not as much interest by the national media as there was in Amber Geiger and even Roy Oliver. So I'm but honestly, I've only really seen ABC Network. I think that some.
You there, Rebecca? Did we lose her? Might have lost her. The cellular signal in that courthouse is kind of wonky. It's kind of dicey. So I guess we lost her. She'll call back. So somebody was asking if there's any questions from the jury. Yeah, they sent out a question. We didn't see the actual text of it, but they wanted sticky notes, and they wanted to see some kind of evidence. We don't know what that evidence was. The judge did not elaborate with us. So, sticky notes. Read the tea leaves on that.
I still feel like they are going to use them to vote. Maybe they're going to use them to put points of contention up on the wall in the jury room.
Hold on one second.
That's all I can come up
That's
with.
all, that me too. So let me. Okay.
Here comes Rebecca.
All right, Rebecca. We lost you there for a sec. Go ahead.
Yeah, I walked across the hall because there was a reporter doing a live shot. It was not allowed. So, but I mean, that's basically what's going on here. So.
Yeah. Somebody else is asking, why did this take 3 years? So. I mean, that was a variety of reasons why it took years. I mean, it was COVID was part of it. We didn't have.
Well, yeah. I mean, it was this killing was 3 months prior to the shutdown, right?
Right.
Yeah.
They said COVID, and then you had, so we didn't have trials for what? Rebecca, wasn't it just over a year that there were basically no trials anywhere? I mean, it was a long time.
Right, and then remember there was the whole issue with the first judge, and then the defense asking that judge be removed, and then a new judge, and so all of that I think obviously delayed it, and then one of the key defense attorneys, the lead defense attorney Jim Lane was sick throughout some of those months, and so there were some delays because of his illness, and then ultimately he died on the eve of the trial. So and it was concerned that they were going to delay the trial because of that, but the defense said no, we're ready to go, and we knew that he was sick, and so we were prepared to go to trial without him. And when they did, they started the jury selection and went on with this trial, and I feel like the public was really antsy and getting frustrated that they didn't have it sooner, and they did not want any more delays, and I think the judge was obviously very cognizant of that.
Yeah, no, and there was a lot of frustration, and I'm reading the comments. People are definitely frustrated by how long it took. Somebody's asking, why was the previous judge removed? Well, there's some coverage. We did a lot of coverage on that, but essentially, the defense was able to successfully argue that judge wasn't fair, and he got removed. And that was Aaron, can you recall? I mean, judges doesn't happen very often.
Yeah, I don't even know the specifics of that, but I do know that he did have to be recused, and that Gallagher's actually only been presiding over the case for
a few months,
6 months maybe. There was also, you all remember, they also tried to move the venue. They tried to move the case out of Tarrant County, so that, I don't know if that caused any delay. Just to go back to that girl's question.
Yeah, they continued with that change of venue motion throughout, but mostly change of venue motions are really about preserving error. So should he be convicted, it's something that a potential point they could raise on appeal. That kind of thing. Rebecca, do you have anything else you want to add, or no, I'll let you go.
No, not really. I just, we're just going to sit here and wait. I'm trying to recall. Do you recall how long it took for Amber Geiger? Well, I just don't recall. But I know that they took a while because, again, you've got to go through this evidence very meticulously. This is not something that is a decision that is easy to make for some of these jurors, I'm sure.
I don't remember exactly how long. I mean, it feels like it was 6 or 7 hours, but that's also been about 3 years ago, and because I believe Atatiana died like the month after the Geiger trial wrapped up, right? Wasn't that?
I believe it was 10 days later it happened.
Yeah,
it was pretty close.
I remember it was like, what? Really?
Well, I was actually at home, and I have a lot of obviously Dallas police sources, but very few Fort Worth police sources. And one of a source, actually I only have like one in Fort Worth because I mainly cover Dallas. But I got a call from this one source and says, "Hey, we have a similar incident here as Amber Geiger, and you probably want to get out here to Fort Worth." And I remember calling our assistant news director, Sheena, and telling her, I think we need to get to Fort Worth because a woman's been shot in her home by a police officer. And I remember just being stunned because we had just gone through the entire trial with Amber Geiger and everything that went with that. And it was just kind of stunning that happened, and I immediately was out at the scene and covered the protests. There were a lot of protests, and people there. I'd say maybe the first night, second night, there were hundreds of protesters.
Yeah, it was pretty wild.
Yeah, it was. People were just they were angry, and so I don't know what the reaction will be if Aaron Dean is found not guilty, but a couple of people that are in this community that have watched this trial closely, that feel like there has not been justice for Atatiana, say that they plan on hitting the streets if there is a not guilty verdict, and so therefore you get all the security, and why we see all the extra troopers and people here in Fort Worth today.
But you and we've both watched this entire trial, and I think that the prosecutors have done a really good job. I mean,
I think I think they did a good job, but it just takes that one juror to say, look, he was an officer, he was in uniform, and he says he saw the gun, and she pointed it at him, and so I mean, it just takes that one juror to either hang the jury or, basically hang the jury. I mean, that happened even in the Shamir case, which was a serial killer. I thought the evidence was overwhelming that dude was. I mean, he was guilty. There was video. There was all kinds of stuff, and there was just that one juror that somehow got on the jury and hung the jury, even though there was overwhelming evidence that he was a serial killer.
There was tons of evidence.
Elderly women. Yeah.
Yeah, Aaron's husband Tolly was with me that day when we were waiting on the verdict, and we were just sitting there looking at each other as the questions came back, and it became increasingly clear that the jury was going to hang, and I'm like, no way, this is really going to happen, and boy, they sure did.
And you're just going to find some people. You could find that one juror that maybe didn't answer all the questions on the questionnaire, that didn't, or maybe wasn't even truthful on the questionnaires, even though you're supposed to be, and you're sworn in that you're going to do that. But I mean, you just have that one juror that just was not going to convict anyone ever of anything, and I think that's what you had in that case. So you just don't know with jurors if there's just going to be that one that has a real, either love or hatred of police officers that somehow did get on that that jury that would hang this jury.
All right, well, Rebecca, we're going to let you go, and then we're going to chat for a while, and then see if we get more questions. Hopefully, we do. I mean, I know that questions don't necessarily tell you exactly what a jury is going to do, but it gives you some indication, oftentimes.
So I was gonna mention something about the jury note, actually. So it came to my attention that the Code of Criminal Procedure has some pretty specific instructions on how the jury notes are to be handled, which surprised me just a little bit. So can I tell you what it says?
Oh, go ahead. Do tell.
So when the jury wishes to communicate with the court, it shall so notify the sheriff, who shall inform the court. We know that. Any communication must be written. We know that. The court shall answer the communication in writing, and before giving such answer to the jury, shall use reasonable diligence to secure the presence of the defendant and his counsel. Mm-hmm. Doesn't mention the state. And shall first submit the question and also submit his answer to the same to the defendant or his counsel. Any objections or exceptions. The written instruction shall be read in open court unless expressly waived by the defendant.
So maybe the reason we're not hearing this in open court is Dean has waived it.
Right. So, and this was a little bit of a surprise, but a colleague suggested I have a look at 36.27 of the Code of Criminal Procedure, that even though all proceedings shall be part of the record and recorded by the court reporter, I mentioned to your colleague earlier that maybe the note was made a part of the record because it was marked or otherwise included in the record but not read into the record. But now looking closely at this, it does seem like the defendant through counsel can waive the reading of the written communication in open court.
I guess the question for the bailiff or whoever, Rebecca, is did he waive that right?
Well, of course, the waiver.
We'll go find out.
And the waiver, one would think that waiver would have to be a waiver made on the record.
What's the provision?
Article 3627 of the Code of Criminal Procedure.
3627, Rebecca. Code of Criminal Procedure.
3627. Okay, I'm going to go find out. I'll get back with y'all.
All right, bye-bye.
All right, thanks, bye.
Huh, that's interesting. I mean, because normally they are read in open court, so that's why it kind of surprised me a little bit.
My experience has always been, for the past 20 years, that when there's a note from the jury, all the litigants are summoned into the courtroom and everybody's a part of the conversation. So that kind of blew my hair back.
Which, I mean, the only thing I can figure is that maybe Dean has waived that right, but you would think that would also be waived in open court.
Well, I feel like any time a defendant waives anything, that waiver has to be
in open court.
Part of the record. Now, that being said, it's unusual. That's an unusual provision of the code, because typically all communication during the pendency of a case or during the trial of a case, all the communication with the court needs to involve both the state and the defense. So this is kind of weird, but I mean, I just read it on the statutes, our state's legislature's website, and that's what it says. Maybe I'm missing something. I'm going to continue to read it and make sure that I'm not misinterpreting it.
I don't think you're missing anything. I feel like you read it. It seems pretty pretty clear on its face. Some folks are asking what's going on. Somebody went and I guess bought a car, and congratulations on your new car. So the jury is Lawn Pro was the person that was asking that question. The jury is currently out for deliberations. They went out around 11:15. They've taken a lunch break, so they've been deliberating, I don't know, maybe 3 hours. They have sent out one question. They did not read it in open court, but basically they wanted sticky notes, which I thought was interesting. And they wanted some kind of piece of evidence. We don't know what that piece of evidence was, because we've not actually seen the text of this question. And as we were talking about, normally questions are read in open court, but Aaron just found a provision in the Code of Criminal Procedure that would allow that not to be done in open court if the defendant has agreed to it.
So kind of like at the defendant's request, because if the defendant expressly waives the reading of the note, then so long as the note is made part of the record, it doesn't have to be read out loud into the record. And it can be made part of the record just as a slip of paper that goes in with all the other evidence.
Somebody wants to know, what's he charged with? Well, Parlay, he is charged with murder. But as part of the jury charge, they have also given the option of manslaughter, which Aaron thinks is really not applicable. But, we'll see.
It's in the charge, so whether I think it's applicable or not,
it doesn't
the court
matter.
Obviously thought it was applicable, or that it could be applicable. So for that reason, the jury has to consider it. I mean, they have to consider it. They
can consider it, right? But I see what you're saying. Because manslaughter has that reckless component, whereas murder has that intentionality. And he testified that he was
acted intentionally.
He acted intentionally. So. And I felt like in the Geiger case, and I think this was bore out later on when we heard from the two, there was a couple of jurors that gave interviews after the case was concluded, because jurors can talk after a case is concluded. They basically said that they believed that, her actions were intentional, but they also went with a lower sentence because they didn't think that, she needed to spend the rest of her natural born life behind bars. So I think that the feeling was she needed to be punished for her actions, but not go away forever and ever. I was trying to write down questions as these were rolling by. So someone was asking if there's a mistrial, in other words, if we get a hung jury, does that have any effect on a change of venue motion? Like, does that make it easier to get change of venue?
I don't know that it does, but I qualify that with that I don't know. I don't know that it would, though, because unless there's something that indicates that it was because of where we are that the mistrial or the hung jury happen. I mean, I just don't know how. I don't know how that would make a difference.
Right.
Is that a terrible answer?
No, I get what you're saying. I mean, because what they've been arguing is that, what they had argued in their motions to try to do change of venue is that the intense scrutiny of the case warranted it being moved, and that it was prejudicial and that kind of thing. And when they called in that pool of original 200 potential jurors, they had just over half of them said they had heard about the case, and then they dismissed several dozen people who said that for whatever reason they had, had a bias one way or the other. And then Ryan's looking at me. What you got?
No, I just think we'll play a couple clips.
Oh, do you want to play some clips?
Whenever you're done.
I'm just talking now. I mean, we're just we're just chit-chatting while we wait.
It's from the closings. It's Gil and then Dale Smith. We played a couple different ones earlier, but we can play new ones if you want.
So, all right, we're going to play some more from the closing arguments, because it's kind of fun to go back and, because when you're listening to this stuff in real time, you're just trying to scribble it down and keep up. So, Ryan is going to. So, you're going to play them both back to back or one at a time?
We'll play one at a time, and then y'all can talk about it if you want, and we can go to the next one.
We can do that. Okay. So he's gonna. So Ryan's gonna play Gil first. I really feel like people ought to see you at some point. But at some point, I'm gonna introduce you to the YouTube jury. I don't feel like you should just get to let go and not get introduced to folks out there. But anyway, so let's go ahead and play Bob Gill's this segment, this clip from the closing arguments.
And you heard from
It didn't play out. It's I'm not sure what happened. It just stopped playing out. So.
All right. Well.
Now he's really not going to show his face.
Now he really doesn't want to show his face. That's it.
Yeah, I really don't. Let's try the Dale Smith.
You gonna try the Dale Smith? Okay, let's try that one first then. Gosh, I got two.
She never had a chance.
Who's gonna play? Well.
No.
We
Is our software decided to be wonky?
It requires a restart from time to time and to play out the videos. So we've been streaming a long time.
We have been streaming a long time.
So, well, we'll just keep going.
Is there? It used to be there was a limit on YouTube, like 8 hours or something. Is there a limit still?
No, it's like 12 hours if they don't to archive it. But you can stream forever long. Hopefully, this doesn't go.
Oh, I mean
today's at least. We'll see.
We'll see. Yeah, at some point I'd like to get home to see my kid. So we're gonna give up on trying to play these.
Yeah, it's gonna have to do a restart, so we'll just have to circle back.
All right, he's gonna fix it and fix the technical issue, and then we'll just keep going. Did you find something else in the law?
Oh, currently no. Those are all the law updates I have for you at this time. But I mean, I'm really quite surprised by that discovery. Well, just because I've never had that experience where I've not had everybody in the room where it happens. You know what I mean? Like everybody is a part of the reading of the notes, the responses to the notes. People have opinions about how the notes should be responded to. Many judges, wise, thoughtful judges, appreciate the input from the parties. So I just think it's interesting, that the code doesn't really even require that the state be notified of the contents, and that the defendant can waive the reading of the note. But to be fair,
Is your mic on?
Is my mic on?
Sorry.
Earlier, y'all were talking about whether it has to be read into the record. I also don't know that I've ever had a note read into the record. I feel like it's just been discussed amongst the people in the courtroom. Are you on?
Yeah, you're on.
I don't know. Somehow who knows what I did? I'm technologically deficient. Sorry guys, I'm sorry. I must have somehow hit the on-off switch. Ryan, also, folks don't like the music that you're playing on the slate. I feel like, can you pick better music? I mean, folks kind of don't like it. What'd you do?
We have copyright restrictions.
Oh, we have copyright restrictions. Gosh, copyright. All right. Well, I'm sorry, guys. I can't fix the music. So, yeah, and you've been doing this a long time. That's kind of like when you find those weird little things in the law that even though, I don't know how long you've been an attorney, but you've been an attorney a long time.
20 years.
A long time, yeah.
This
and
is
so,
my 20th
because I think
year.
when we first met, you were still in the DA's office.
Yeah, that's where I worked for the first few years.
Didn't you work in child crimes or something?
No, never. No, I did family violence and adult sexual assault. So I was not assigned to the child abuse division.
I feel like, I just can't remember. I feel like we met on a case, but I don't remember what it was, and I've slept too many times since then. So somebody's asking, is the jury sequestered? Well, if they cannot come up with a decision today, a verdict today, then yes, they will be sequestered.
And they're currently sequestered of sorts because they're together by themselves and no one else is around them. I mean, when the jury deliberates, they're certainly in private, and not even the sheriff can be in the room.
Wow.
And usually the door is closed and locked, actually.
Wow.
So.
Somebody's wanting to know why Dean wasn't charged with child endangerment.
That's a good question.
I never even thought, it never even really occurred to me.
Well, because the nephew was in the room where he shot his gun.
I mean, I guess you theoretically could.
Theoretically, yeah.
I mean, I guess if they'd have wanted to, to go that route, to my knowledge, there was no discussion about going that route.
And there was also, to my knowledge, there was no discussion about any facts that necessarily would have supported the that kind of allegation.
Right.
Right.
Okay, so somebody's just wanting to know more. Law and Pro wants to know a little bit more about. Question for you, Aaron. As a prosecutor, do you get to pick the type of cases you work on?
In big counties like Tarrant and Harris and Dallas, of course my experience as a prosecutor was only in Dallas, but Tarrant's a pretty big county. When you get hired to work at the district attorney's office and you're a prosecutor and you work for the elected DA, you are assigned to a division, or you're assigned to a court.
And you serve at the pleasure of the DA.
For sure. And you work where you're assigned. And could you have input into your position? Maybe at a, in your job, if you have like a review or a meeting with your supervisor and you're given the opportunity to give your own feedback. Maybe you tell the boss or the supervisor, hey, I'm really interested in working on elder abuse cases, or I'd really like to participate in the community prosecution unit. Maybe you could have some input, but pretty much you work where you're assigned.
Somebody's asking, Dragon Zone wants to know, and I'm sorry, Dragon Zone, that I missed it earlier. It's really kind of hard to keep up with these questions as they're floating by, and lots of comments. Somebody wants to know, how will Dean's testimony affect the verdict? Did his testimony help or hurt him?
I guess that remains to be seen.
I mean, yeah, that depends on how the jury decides to, decides to see it. I mean,
if he hadn't testified, nobody would know his version of events. Now, I'm not suggesting that the jury or anybody has to believe his version of events, but if he hadn't testified, absent his testimony, I mean, no one would have really been able to learn about his perspective. I don't recall that his female partner or the other responding officer.
Well, she didn't see the gun.
Right.
Yeah, nor articulate.
Well, she certainly. Then that she didn't add that, but she also probably wouldn't have been able to speculate as to what Aaron Dean experienced or perceived. So you could argue that his testimony helped in establishing his defense claim, his self-defense claim, but also, depending on whether the jury gives him credibility, you could argue that his testimony hurt him.
I mean, I would say that there were parts of his testimony that hurt him. But he had to give the testimony in order to make the self-defense claim. So, he's kind of caught in a bind there. He really had to testify, and we had never heard from him before because he did not give a statement after this incident originally happened. And he has that right, guys. This is, he had under the Fifth Amendment, he did not have to give a statement. And so
even though he's a police officer.
Okay, in the internal affairs investigation, you can be compelled to give a statement in an internal affairs investigation. They give you what's called the Garrity warning, but under Garrity, the statement that you give in that internal affairs investigation cannot be used against you, right? I mean, that's part of the deal. Because you can't make somebody give up their Fifth Amendment
in
rights.
a criminal prosecution.
Right.
They
Right.
can use it against you in their administrative dealings with you as an
or
employee.
in a civil case, right? But
Or
they
a civil
can't.
case.
But they can't use it against you in a criminal proceeding. And so he quit before any statements of any type. He resigned before any statements of any type could be taken.
Or compelled.
So somebody wants to know, if Dean is found guilty, will there be victim impact statements from Atatiana Jefferson's family? Well, I'd almost guarantee there will be. Victim impact, though, comes after everything.
After sentencing. But there could be testimony during sentencing. If there's a punishment phase of this trial, I fully expect that the state will call witnesses to establish the profound effect of Miss Jefferson's loss on their family or their community. I expect that testimony would come to pass.
You get some like during punishment. You get some of that type of testimony during punishment. But the real emotional stuff is what you get during the victim impact, which is after everything's been done
and after the individual has been sentenced,
and the jury has been released.
Sure, but the jury can participate. I mean, they can
if they want to hang around. Yeah.
The jury, if the jury renders punishment and then the judge accepts the sentence and then issues the sentence against the defendant, after that, before the defendant's committed to the custody of the sheriff or however that transpires, after that, the state has the right to present victim impact, which is not on the record. It's not a question and answer. It's not a dialogue. It's just a presentation of the statement, and it can be more than one person. There's not usually a time limit.
No.
And the jury can stay. That individual jurors are not excluded from that part of the process. They're also not necessarily included. They're not required to be.
And I always find the victim impact statements to be pretty powerful in general, because that's the moment for the family or the friends to address the defendant directly. Those are usually pretty powerful moments. Actually,
that's a really good point. That the victim impact statement is the survivor or the family member or the loved one or the friend, coworker who comes and speaks after sentencing, and it is directly to
addressing the
defendant. Whereas, I guess the difference is that if there's testimony during the punishment phase, the testimony is evidence which is presented to the jurors who are at that point the fact finders on the question of what the sentence should be.
Well, and really the really powerful moments in the Geiger trial, where the brother, both of them, John's brother, asked to hug
Amber Geiger,
which was frankly one of the most wildest things I've ever seen in a courtroom. I mean, and then it got wilder after that when the judge came down and hugged Geiger and gave her a Bible, because that all took place during victim impact. And talk about being completely unexpected. Again, I don't think we're going to see any hugs or Bibles being handed out to defendants in this case. I don't see Judge Gallagher doing that. That doesn't strike me as a possibility. But it was pretty wild, because I don't remember which legal guest I had with me that day, but whoever was with me, we were just sitting there going, wow, this is stunning. I think it might have been Judge Conyers I had with me that day, but it's been a while, and that was just an extraordinary, extraordinary things that happened in that courtroom that day.
And it was just one after the other. It was just surprise after surprise. I agree.
Somebody sent a nice comment saying that you're better than Tolly. But it's a fellow lawyer. I think he's just joking.
Oh, how dare it.
But I think he means it seriously, but also joking. Because I think y'all are equally as good.
I'll have to check the identity in a moment. Don't let that scroll too far.
They sent it to me on private.
It's not
message.
true.
I'm just laughing and laughing.
We all know. We all know who's the better lawyer. The younger, better lawyer.
So let's see. Somebody's asking about jury questions. Okay, so if you weren't watching, the jury, we didn't see this again because they did this outside. They did not do this in open court. The jury sent out. They wanted some sticky notes and they wanted to review some kind of evidence. We don't know what that evidence was. We don't know. Was it body cam? Was it some portion of
the forensic interview, maybe
Zion's?
of the child? Mm-hmm.
I mean, we just don't know. And so that, lots of questions, and the sticky notes, that could be maybe they're taking votes, maybe they're who knows?
Maybe it's brainstorming, workshopping. It's how they're gonna. Maybe they've decided to. You said take a vote, or maybe they're gonna put points of contention up on the wall and try to
work their way through.
Or maybe
it.
people have doubts. Maybe they're going to write their doubts on the sticky notes and see if they can eliminate the doubt through the deliberations.
Yeah. Somebody wants to know, how long will the jury be anonymous? I mean, we never unilaterally do anything to identify a juror. That's just not what we do. But obviously, if a juror chooses to talk to us once the case is concluded, right? I mean, completely concluded, then we have had situations where we would identify a juror if they wanted to be interviewed. But a lot of times, jurors, they don't want any part of that. And
well, I think it's I think that's very respectful of y'all to allow them to keep their not anonymity. They're not anonymous. They're part of the process, but.
I think if we didn't, I mean, I think if members of the media engaged in sort of that gonzo journalism and tried to do that kind of gotcha stuff and do that to jurors, we would lose the privilege that it is to be able to live stream trials. We just can't do that. I mean,
well, and I also think about what effect would that have on the people, like the civilians in the county, and how they might or might not respond to jury summons. And I would think nobody would want to discourage people from participating in the process or, executing their civic duty or privilege, as the case may be.
Absolutely. I think, serving, I've never actually served on a jury. I got called down for jury duty one time. It's just really kind of amazing that I've only been called down one time.
In Tarrant County, I assume.
In Tarrant County. I'm from Tarrant County. I live in Tarrant County. One time it was a civil case. It was like a minor accident or something, and I wasn't picked. But I have known journalists who have been picked. Jennifer Emily was a longtime court reporter at the Morning News. Was picked on a jury. After she was done with that, she actually wrote about it. And I actually think journalists could potentially be halfway decent jurors. I mean, maybe.
I think probably if your job is to find the facts and expose them.
That's true. And I'm willing to listen, right? I'm willing to go, okay, I'm willing to consider it all. And that's why people, when they ask me, on this, like, well, what do you think should happen to Aaron Dean? I've given answers where I could go either way. Like, okay, I could see this and I could see that. And so I think in my line of work, a lot of times we see nuance. Things are shades of gray. Things are complicated, but ultimately the jurors are going to have to make some black and white decisions here in terms of the law and what the law says. So somebody's asking, Tiffany wants to know, how long will sentencing be after the guilty verdict? So if he's found guilty, the judge could immediately move into the punishment phase, and punishment phase, I don't know, usually lasts like 2 or 3 days, right? Typically?
It depends on the case. And, in a case where you have a defendant who, let's say, maybe has a lengthy criminal history, for example, and that needs to be presented to the jury, that could take a while, depending. I don't think that is at play here. So that may not require a lot of time, but then
if I had to make a guess, I'd say 2 to 3
days.
days. 2 days, yeah. I mean, because it's kind of like a punishment phase is like a mini trial. You have opening statements, you have testimony, you have closing statements. So it's a mini trial. The only time you don't really see a punishment phase is when you have what's called a mini cap.
Right, when there's an automatic sentence based on the conviction.
Right, and we saw that in Yasser Saeed a few months ago, and I would have loved to have been able to do this with Yasser Saeed, but in that particular case, the judge was just like a day or two before the trial started, agreed to let us have cameras in the courtroom. And so in order for me to do this kind of setup where I have folks like Aaron come in and spend all day with us, that takes me a while to work out the schedules, and because lawyers go and they make money and gotta work. And because we don't pay folks to come on here, so it's like I gotta work with their schedules. And so
it might have been hard to pull that together so quickly.
I couldn't have done it. I mean, if we had found out with Yasser Saeed maybe 2 weeks out, I might could have. It would have been a heavy lift, but it would have been. But anyway, in the Yasser Saeed case, Saeed was a mini cap, because the DA's office had not gone for the death penalty, and Saeed he had killed. Oh God, that was a horrible case. It was an honor killing. He had killed his 2 teenage daughters because basically they wanted to live American lives and not live the way he wanted them to live, and he killed them, and he disappeared for I don't know how many years, I forget now. It was a long
almost
time.
A decade?
It was maybe more, and I covered that. Actually, that particular case I started covering when I was at the morning news, and I
was still at the DA's office.
And I even was in a documentary. Like I said, I was still morning news, and it's just one of the most heartbreaking cases I've ever covered, and it killed me what happened to those girls, because one of them wanted to be a doctor, and I was super smart and intelligent,
darling, yeah.
And then of course ultimately, like we all figured, turns out his son and his brother were helping hide him, which absolutely did not shock me at all. I would have been shocked had they not been involved in hiding him. But anyway, we didn't have a long story around to say there was no punishment phase in that case, because when the jury found him guilty,
there was an
automatic life sentence. Okay, so let's see here. Somebody wants to know, did Aaron Dean have any complaints on him regarding his abuse of power? Not that I'm aware of. I mean, Aaron Dean had only been a police officer. He'd only been on the streets about, I think it was a year. So he had not been on the force very long. So he wasn't like an officer where you could look back and see a long, history in terms of IED and that kind of thing. So no.
And, I mean, the state would have had to have filed a notice of extraneous if they had intended to try to introduce any other bad acts or extraneous offenses. And I feel like there's a chance we would have known if that was part of the plan. Of course, anything could come up in the punishment phase, even if it wasn't something sustained or investigated by the department.
Are there any limits in punishment?
Limits?
I mean, is there any? I mean, is it no holds barred, or?
Well, I mean, relevance is the only limit, and what is relevant to punishment of the defendant has everything to do with his or her prior behavior or other crimes. Character evidence becomes fair play. And then obviously also,
like if they could show that, like in the Geiger case, there was things that came up about her dealings with black people, things that came out in punishment that affected that. So it'd be maybe something like that.
Sure, or if Aaron Dean has a colleague who wants to say something good, bad, or otherwise, that's going to come out during sentencing. I mean, not just bad stuff,
but good stuff too.
Good stuff too, yeah.
That's why, because it's a mini trial.
And and the whole point is the state is going to try to achieve whatever they want to achieve in terms of punishment, and then the defense is probably doing everything they can to mitigate the punishment or lessen the blow. So I fully expect that the defense would call witnesses to establish prior good acts or positive character traits or other things like that on behalf of their client.
Somebody wants to know why police were able to talk to Zion that night.
So why the police were able?
Yeah, why they were able to interview him. That was kind of one of the recurring questions that we got, is why were they able to interview him? Because as far as we know, I'm not aware that anybody gave permission, because obviously Atatiana is dead. She couldn't have given permission.
So I feel like he was not interviewed by police.
He was interviewed by a forensics interviewer.
By a forensic interviewer who would have been part of maybe Alliance for Children. I didn't
Yeah,
watch
it was
that
like
part.
it was like one
Which
of those,
is the advocacy center that exists exclusively for protection and preservation of the usually children who are survivors of abuse or neglect or sexual abuse. And then also when there's a situation and there's a child witness to a crime, it does seem like it would be protocol for the child to have been forensically interviewed. In fact, if police had interviewed the child, I would have thought that that would have been inappropriate.
right, especially because it involves a Fort Worth police officer.
Well, especially, but also just because.
And also, kids have to be interviewed
a certain way,
very delicately.
And also, it's really, there's so much suggestibility, and there's so many things that a child might answer a question in the presence of a person of authority, like a police officer or a teacher or a parent or a priest or a rabbi, that the child might respond differently. And then furthermore, these interviewers who work at these advocacy centers do have specialized training to elicit presumably truthful content from the child witness. And then there are also resources available in the event that there's something traumatic about the experience and things like that.
Didn't some of that style of interviewing come into in terms of having really specially trained people to interview children? Didn't that come into play after we had the I forget what it was called. Remember the case, I don't know, maybe it was 30 years ago, where they had the kids that all claimed that there was like a satanic cult in the preschool or something, and there were all these people convicted, and it ended up being that like the kids were all coached and I feel like there was a lot of changes made in the fallout from that case in terms of how kids are interviewed. And was it the McMartin case or something?
I don't know. It sounds terrible.
I just remember that. I don't know if I remember it like I feel like it happened when I was younger. I feel like that was maybe in the 80s or 90s. It was a long time ago.
Well, I don't know about that, but I don't actually know about the history and genesis and development and evolution of the advocacy centers because I don't know about that. However, I do understand that the purpose of the forensic interview is to avoid problematic testimony or suggestibility or influence or
That was a
compulsion.
daycare sexual abuse case in the 80s.
McMartin.
And it was prosecuted in Los Angeles. And this was where the people that ran that daycare were charged with hundreds of acts of sexual abuse. And I remember it became. Anyway, I think one of the fallouts from that case was, like I said, was that a real change in how kids are interviewed and kind of setting in place protocols and that sort of thing.
Even more recently, down in sort of maybe the Austin or surrounding areas, there was a case, there was an allegation of child sexual abuse made against a young man who had dreams and aspirations of being a UT football player and this, that, and the other. And I can't remember all the details. He was ultimately exonerated, but I believe that part of one of the child's forensic interview moments, a police officer or a sheriff or a detective walked into the room while the child was being forensically interviewed and maybe guided the interviewer on a question, and it was pretty apparent that it tainted the process and that the child responded differently, and I think that was a more recent example of how important it is for that process to be preserved and respected, and for those for kids to be interviewed by forensic interviews and not police officers.
Yeah, and so I think that's part of what you're seeing in that kind of situation. Sorry guys, I'm also answering questions.
Well, and to be fair, there are plenty of times when you have a criminal case and there's a child witness or a child ear witness or eyewitness or a child who's present, and the police do have contact with the child, maybe at the scene to which the police respond. And I don't know that there's anything wrong or inappropriate about that. If police are in the middle of an investigation, they're trying to identify if there's an ongoing threat or who the perpetrator may or may not be or what may or may not have happened. I don't think that you would be surprised to see information about a child witness from a responding officer or from crime scene or from...
Right, but when they sit down for that sort of more,
intense interview that kind of maybe elicits sort of testimonial comments, yeah.
Okay, so I'm looking more here at questions. So Someone's asking, are there any alternate charges? Yeah, the jury is considering murder, and which is, of course, that you did the act intentionally, and that's up to life. And then they're looking at, they also included a lesser charge, a second-degree felony of manslaughter, which is more of a reckless component, and that carries up to 20 years, I think. I think it's 20
manslaughter
years.
is the second degree, 2 to 20, yeah.
2 to 20. Let's see, I'm looking here. Somebody's asking, is Dean in custody? No, he is not in custody. He has been out on bond pretty much since this happened. Someone's wanting to know what happened to the other officer, Officer Darch. Well, she's still on the police force, so she, as far as I know, didn't do anything wrong. Somebody wants to know, did Dean say anything to Zion after entering the home other than hands up? Not that I recall.
Is the question whether the Aaron Dean talked to Atatiana's nephew while at the...
So he says, did Dean say... because when he goes in, he says hands up, obviously, and so because what happens is no, I don't think he says anything beyond that I recall. I mean, I'm going on my recollections of that body cam, and Officer Darch gets Zion out of the house pretty quickly after that. Obviously, for obvious reasons, right? Let's see. I'm looking here to see if there's any more we want to answer before we take another break. Somebody wants to know, have you ever worked with a judge who locks the courtroom? I know we've had Dallas County judges that do it.
Yeah, I feel like I feel like the courtroom is supposed to be open to the public. Period.
But we have had judges that do it.
Well, I feel
there's
like
sometimes some legitimate security reasons.
Legitimate security reasons, or for logistical reasons, a courtroom or bailiffs deny access to public during, for example, testimony of a child, the victim impact statement of a family member who've lost a loved one or whose child survived a sexual assault or something like that. I think being excluded temporarily from the courtroom is one thing versus a courtroom that is locked. I think the courtroom's going to be locked if there's no proceedings happening necessarily. So that doesn't really blow my hair back. But I don't know.
But generally, courts have to be open. I mean, when there's actual proceedings.
When court is in session, it is supposed to be a public forum where to which the public has access. Yes, but I do think there are times when it is necessary and appropriate for that access to be restricted or limited.
Let's see. Somebody's asking if we can go back and explain the blinds being up or down versus the pictures the forensic photographer took. Now, I don't think I can go there because I don't really know the answer to it, and I don't want to speculate. I don't remember that part of the testimony well enough to be able to talk about it. Okay. I think that's pretty much it for questions in the chat right now. We're going to actually, folks, I don't know. There's a couple more floating in here. So why would two rookie partners be the only one to respond to the call? Is there no supervision monitoring? I mean, given the nature of the original call, I don't think it's unusual to have two officers. I would say that, it would have been better to have, a more veteran officer. I think in general, police departments need to look at doing a better job pairing up. But it's not horribly unusual. It's really the question of what happened once they got there.
Also, I feel, and I don't know, I've never served in that capacity, but I do feel like when a call comes out, the way officers respond has to do with how their department's set up. Maybe if they're the closest to the call, maybe, officers get called out on...
It can be staffing that night, too.
Sure. Where you're assigned and when you're assigned, who else is nearby, whether you're riding in one man or together. But police officers get called out to incredibly dangerous and incredibly dangerous situations, and they don't know that until they're there. And there are plenty of calls where there's only two responding officers and there's no supervisory action on scene, and that's not unusual, and that could be a felony domestic violence, or maybe more officers come for the time when arrest is effectuated, but I don't think that that's totally out of the ordinary.
No, it's not. Okay, so do we know how many people were in the house? Well, it was just Atatiana and her nephew, Zion. The grandma at the time was in the hospital. Okay, this is the curious question. How long does the average attorney work for the DA's office? How long did you work in the DA's office?
8 years and some months.
Is that pretty
Tolly
typical?
worked there, I don't know. I mean, probably not. I think Tolly worked there for 4 years, 5 years? I don't remember. There's some people who, I have a dear sweet friend, Christy, she worked there for a year, maybe a year and a half. One of my colleagues with whom I office now was at the district attorney's office for at least a year, maybe almost 2. And then, anyway, I don't know, it really varies, I think. Some people stay at the DA's office forever and ever. I feel like Miles Brissett, who was on the defense team on the Aaron Dean case, I feel like Miles Brissett was at the district attorney's office in Tarrant County for a long time.
I think he was. No, he was. He was.
Because he was
No, he was. Because when he... see, this is what happens. Memory is a funny thing, and the person who was sending me a message earlier can correct me on this, but I believe when he... So Miles worked on he was basically, he's kind of a video expert. I mean, he's like really smart guy.
The tech guy?
Techie guy. And so in the Eric Williams case, Miles was the techie guy because there was a ton of surveillance case and a ton of surveillance video in the Eric Williams case. And Eric Williams was the justice of the peace down in Kaufman County who killed the DA, his wife, and the other prosecutor, which was
the first assistant. Yeah.
The first assistant. What a wild case. I mean, that was. I will never forget, Aaron. I was still a Dallas Morning News reporter, and basically Miles worked on that case because he worked with Toby Shook and Bill Werski.
I didn't realize that he worked with them on that. I just remember.
But I think he was in the Tarrant County DA's office.
I think so, because I think that when I was in law school, I interned at the DA's office in Tarrant County, and I feel like he was a prosecutor there at the time.
He was.
He has a youthful look about him, so I think maybe I thought he was younger, but actually I think he's been a lawyer for like 20-something years.
Yeah, but that's how I met Miles, and that case was wild
crazy.
Because I remember I was sitting in the because now you can see we're chatting, folks, because we're just waiting. I was sitting in the newsroom. It was I'd gotten to the newsroom kind of early that day, and a lawyer I know who works down in Kaufman, who I don't talk to that often, but just so happened that particular day I had been dealing with him on something else, and he calls me and he says, a prosecutor has been killed in downtown Kaufman.
In the parking lot of the courthouse.
Yeah, his parking lot nearby, and I said, what? Say that again? And I can't recall if he gave me the name at that point, but he might have given me the name as Mark Hassey. And so, but we obviously didn't report that immediately, and so, I'm running around, making sure we get people down to Kaufman, and that was a crazy deal, and I remember that, there was a lot of speculation early on about whether or not this was because Hassey had prosecuted some biker game types, and I did a story on this speculation, and which later on I learned one of the hard lessons I learned out of that case was that was probably not a story I would do again, because it turned out obviously that it was had nothing to do with these biker gangs. Not biker gangs.
Like
it was AB. It was Aryan Brotherhood.
Mm-hmm.
It's Aryan Brotherhood. Sorry, I've slept a few times since I covered that case. Anyway, so
they had the local police had details on, what do you call it? I can't think of the phrase that they use. Closed patrols on the homes of anybody in law enforcement, judicial administration, prosecutors who had ever even been maybe associated with working on those cases against organized crime.
The fear was palpable.
It was intense.
And so the DA, Mike McClellan, came out and gave this press conference where he said, basically said to the killer, at that point they had, they had not arrested Eric Williams, and it was not publicly known yet. The killer at that point of Mark Hassey was on the lam, and so he comes out and he gives this press conference where he says, we're gonna follow you down whatever deep dark alley or whatever hole you're in, and we're gonna get you. And Eric Williams, we later learned, saw that and decided that he changed his order of who he was going to kill. He had a list of people he was going to kill. And he decided, when they had taken the extra security off of McClellan's house, and I believe it was it Easter weekend? I want to say it was Easter weekend.
It was because we made Easter cupcakes for a police officer who was assigned to our neighborhood.
Yeah, and
cookies.
I'm sitting, this time I'm sitting on my couch at home when the phone rings, and it's a source, and they said, Mike McClellan and his wife are dead. And I just said, what? Can you say that again? And I'll never forget something that Bill Worski said to me, because this is where, I have just such immense respect for him. He said to me, because all this speculation about the Aryan Brotherhood and all this stuff, he said, Occam's razor. Occam's razor.
The simplest explanation is the most
answer.
likely. Yeah.
And
who said Occam's razor to you? Worski?
Worski.
That sounds like something he would say.
And so Eric Williams was the commonality between Mike McClellan and Mark Hasse was they had tried, the only case they'd ever tried together was Eric Williams. He had been convicted of stealing county property.
And that's how they cracked the case.
And so, and they did him and Toby Shook did a masterful job of cracking that. It was a pretty wild deal.
I went out to, that's the only time I've ever been to the Rockwall Courthouse, is we went, my same friend Christy, and I went to the Rockwall Courthouse to watch the opening statements.
Yeah, well, and so around that time, I when that case went to trial, I had just come over to work for Channel 8. I'd been here maybe a year, so that was actually my first trial that I covered as a TV reporter, and that was wild. I mean, because the difference between newspaper and TV, obviously there are similarities to the job, but there are a lot of differences, right? The writing style, and you really have to take an enormous amount of information and compress it, and it's kind of a running joke with some reporters like Rebecca and Jason Wiley, because I used to kind of make fun of TV reporters, and then I became one. I was like, wow, this is not so easy. So anyway, but yeah, that was quite the case. But that's how I met Miles. That's a long way to explain how I met Miles Brissett, and he was
from the Williams trial.
From the Williams trial, and very good attorney, and I met, and then of course Bob Gill was became his law partner, and they've tried a number of police officer cases where they're the defense attorneys. They were also the defense attorneys for Roy Oliver, who was accused of killing Jordan Edwards. And these are tough cases, and regardless of how you feel about Aaron Dean or Roy Oliver or Amber Geiger, they didn't try Amber Geiger. They deserve representation just like anybody else, because that's the nice thing about our system. All right, I'm looking back to see if I miss any questions here. I'm going back, folks. We're probably going to take a break here in a few minutes, because we have now been talking for more than an hour, and I do have the gift of gab, but I'm kind of running out myself. So, all right, folks. So here's what I'm going to do. We're going to take a break till about 4:15. We're going to come back around 4:15, unless we hear there's a jury question. If we hear there's a jury question, we will come back before that. So if there's something or a verdict, I mean, obviously a verdict, yes, we'll come back. If there's any kind of verdict, if there's any kind of new information, we will come back. So what that means is you really got to stay on the live stream. You really can't go away, because you might miss something, and you don't want to miss something. So we'll be back at 4:15 or sooner if something happens. All right, we just got word that the jury has said they are going to go until 7 o'clock. They went out for deliberations around 11:15. They took about an hour's break, which means they've been deliberating for, I don't know, around 5 hours, Aaron, about 5 hours. And so the judge had told them originally that they could go till midnight, but they have now chosen to go till 7. And if they don't come to a verdict by 7 o'clock, they will be spending the night in a hotel.
Together. Well, separately.
Well, separately in rooms and obviously cut off from the outside world. What do you make of this?
Well, I think that the judge, by giving them this extra time today, that indicates to me that the judge would prefer not to make them be sequestered. I mean, he's willing to give them extra time so that they don't all have to go spend the night away from their families. But it seems to me that they're working hard, and I don't know. I predict we might have a verdict before 7 p.m.
All right. Well, we'll see. I mean, of course, I gave up on the jury prediction business during the Geiger trial since I was wrong at every step of the way. So I've pretty much figured out that I'm always wrong. But, the only earlier, I guess it was around, I don't know, 2 o'clock, they came out and they asked for some sticky paper, school supplies, sticky paper, which made you think maybe they're, counting up votes, maybe they're writing important concepts down on the piece of paper, I don't know. And they also asked for some photos. I'm still not clear on what those photos were.
I do wonder whether they were the photos that the prosecutor laid out during his argument, maybe, that displayed the damage to the window, or maybe the injuries to Miss Jefferson's person.
Because that certainly would have been the last photos that were mentioned to them. So
yeah, that's
possible,
true. There probably are hundreds of photos that they might have requested. They've created stills from the body cam, right? Did they create still photos?
Yes, they did.
So maybe those might have been of interest.
Yes. So, I mean, I think, the thing about a jury is they are, at this point, the ultimate fact finders. And, they're going to do what a jury's going to do. Are you surprised, Aaron, that we haven't had a lot of questions? I mean, we only had that one question come out.
I mean, I don't know. I think that they are probably in a battle over the law. I have a feeling they are working through that jury instruction, and I don't know. I think they're hung up, not hung up, meaning that they're a hung jury. I think that maybe they are really
parsing
debating the language about whether he could be justified if Miss Jefferson was not acting unlawfully. I think that could be a major point of contention. There may be some folks on that jury who are going to just go with Gil, the attorney for Aaron Dean, and they're just going to say, can you ever point a gun at an officer? And so they're going to find that her behavior was unlawful and that he was justified, Aaron Dean was justified. And then they're going to be people completely on the opposite that are going to say, how did she know he was an officer?
Mm-hmm.
And I think that's going to be a big sticking point. Yeah.
Somebody's saying that we look tired. I'll be honest with you. I am tired. It's been a long day. This is kind of par for the course. With trials, you hurry up, you wait, and then this is the hard part is when you're waiting on these deliberations. Because we'll find out maybe today or tomorrow whether or not he's convicted or not. And of course, if he's convicted, then we go on to punishment. And if he is acquitted, well, then that'll be a different set of things controversies that will arise. But yeah, I mean, it's just the hurry up and wait that we'll have to.
I can only imagine those lawyers and judges and civilians, just people who are there at the courthouse. I can only imagine how tired they are. They've been working all day, and the people who have vested interest in the outcome, I bet the level of exhaustion is just high.
Somebody pointed out that do the juries normally take a vote right at the beginning?
It's totally up to the jury. I think that they have to elect a foreperson at the beginning because that's what the judge tells them to do. But after that, I don't know. I've only ever served on one jury, and I don't recall taking an initial vote. I recall beginning conversations and beginning deliberations, and it was only after a while then did our foreperson say, why don't we go around the room and see kind of where everybody falls on what their verdict would be. So it just depends on the foreperson and what his or her energy is like, or how he or she takes control of the room or defers to his or her fellow jurors. Like, who knows? I think that's probably common, and I've heard that. Well, we took an initial vote and we were 8-4 guilty, and then after 3 hours we were 12 guilty, or the other way.
Right. Generally, is there any rhyme or reason to who gets picked as a jury foreperson?
Who knows? I mean, I think that there are some people who have like a personality profile that is that the other jurors can pick up on, and maybe they'll say, hey, we think you should be, hey, Mr. So-and-so, why don't you take that role? And then I'm sure there are plenty of people with a personality profile that would volunteer or want to be. I have had a number of juries where when we find out who the foreperson is, we are blown away because we think, oh, that guy, we never would have guessed he would have been the leader of that ship. Maybe he was more soft-spoken, or maybe he seemed less engaged, and then, yeah, so no.
Were you the foreperson on the jury you were on?
No. Actually, there was a physician. He was an anesthesiologist, maybe, or maybe he was in emergency medicine, and the other jurors asked if I would, and I said, how about we ask this guy if he wants to be the foreman? And so he was the foreman of the jury.
Okay, well, cool. All right, guys, we're not going to stay on too long because, my plan is to stay here, not on camera, but to stay here physically until the jury wraps up for the day. So if we get a verdict, we'll be ready to go. Erin is going to leave soon because she has children and a husband, and you know,
I'm going to stay as long as I can.
But I super appreciate you coming, and Erin's been with me before on these trials, and we always have a good time. And I know she'll come back for whenever I do the next one.
For sure.
So, all right, so folks, we're gonna take a pause until 7, and we'll see if we get a verdict tonight. Okay, folks, the jury has wrapped up for the night. They will be sequestered, which means they'll be staying at a hotel, and then they will resume deliberations tomorrow morning. They've deliberated, I guess, for about
8 hours.
Well, 8 hours, give or take, with a lunch break. So probably about 7 hours. So that's a long time. And I know in a lot of cases when I've covered situations like this, you'll see the jury want to sleep on it, and then oftentimes we come back and we see a verdict, mid morning or around lunchtime. So we'll just see what happens, and join us, and we'll be back in the morning.